I'm seeking slight accommodation. I have item number 1 in court number 1, Lordship. I'll do
Which
that and
one?
immediately I come.
Which one? There's so many top of the list. Which item?
Item number 1.
That one?
Yes, Lordship.
These are all similar.
Lordship.
These
All
are
the
all
others are similar.
Huh?
Arunachal matter.
This is pertaining to the mining contract.
Yes, 1104 WTC. That one.
Yes.
But here in respect to item number 1, I am for the government. I am paying for an accommodation. Can it be any other day?
Why?
Some, but that is my
No. It's the state of AP has urgency, and it is at the
It will be difficult for me to complete also.
Huh?
It will be difficult for me because I have a lengthy order.
Fantastic. I'm here to hear you. Let us hear the state first, then I'll hear you.
I'm not for the sir. I'm for the petition.
Understood.
Yes.
We'll hear you later on. First, let me get the gist of the state of AP.
I have taken all protection, Lordship, from the state. I have taken all protection. Even my SP is also sitting
Who is sitting?
in the screen, Lord.
We'll see when the matter is. We'll take it up. Don't worry.
Little locum, sir.
Yeah,
Maybe in 10-15
I will,
minutes.
Mr. Advocate General, I'll hear you. Don't worry.
Lord. I deeply oblige.
Mayor, please. In item number 6 to 16.
And
I don't know,
Mr. Advocate General, have you taken any decision as regards this item number 24 onwards? Because these are all matters which have been stuck.
Medical college, Lordship. The matters in Birubari, land area.
Yes.
Yes.
Have you taken a decision? I've asked you to take a decision because in view,
Who is to get up to date. He, because of his mother's Lordship, he is not in Guwahati. He is reaching today. So we'll be requesting for accommodating till day after tomorrow.
because on the last occasion I said, the best would be the
Lordship.
option of let the authorities hear that and finish it. Why should we here let them submit representations before the authorities and you take it? Yes, that
We'll
So,
definitely
if
make my
that is
submission.
so, these matters can be unnecessarily, these are dragging, and in fact, it is not doing good service to you also.
Yes, Lordship. Public interest is in.
Yes, that
So
is
let it
why
come up
you,
day after tomorrow, Lordship. It's 24.
we'll see when the matters. Yes.
Mayor, please. I recommend item number 6 to 16. Morning,
Huh?
today morning we have filed on affidavit.
Item
Then
number?
6 to 16. Top of the list.
Yes.
The morning we have filed on affidavit. Let the affidavit call for. And one more pair, my senior was out of station and she was supposed to come by 12:30. Later, maybe come after 2 p.m. Call after 2 p.m.
Which one? Or the
6 to
6 to
16.
16? Okay, who is your senior?
Yes.
Okay.
After 2.
Thank you.
They have for listing lordship and eviction, I can tomorrow lordship.
What, eviction? Oh, you mentioned it before. I am a junior judge. Mentioned it before, Justice Manish Chaudhary.
Yeah, please, your Lord. To mention item 23, man. Order matters. This is regarding my Lord.
Oh, that one. What
Yes.
had happened?
Yes, my Lord. The Supreme Court has matter is fixed on 22nd of November. So, my Lord, my learned is also there, my Lord. So maybe instead of
At the request of it has been submitted by the counsels appearing on behalf of the parties that the issue which is pending before this court would be taken up, similar issues are being taken up by the Supreme Court on 22nd of November 2024. Accordingly, list this matter again after again on 6th of January 2024. Because this is tagged with me, na?
yes.
So I may not be there in the month of December. So
Hello, interim may be continued.
interim orders passed earlier shall continue.
Wait, please, your lordship. Lordship, I beg to mention a listing of a writ petition, lordship.
Why?
Lordship, the matter pertains to demarcation of plot of land, lordship.
Go mentioned before. This is Manish Chaudhary.
I beg to mention item number 70, madam, 70. This matter has become an adjustment.
Who are you? 70.
70, madam. I'm mentioning on behalf of Mr. R.S.
Where is he?
He has some problem. Madam.
Where is Mr. Ken Chaudhary?
He-
Or where is Mr. B. Koshak?
because
Then how can I say it to be infructuous at the instance of some counsel who is not there? You have not signed the wakalatnama. Tomorrow the problem will be that you are taken up and dragged to the bar council and then you say, oh, that judge has made that mistake. Absolutely no. Get hold of all these three. Either of it.
Then Lordship may take up to madam, the R.S. has some medical problem today, madam. He will send to doctor.
It has been submitted that the counsel, Mr. R.S. Mishra, is having some medical ailment. To accordingly list this matter again on 11th of November.
Okay, pause.
17 personal appearance.
You are the senior superintendent of police? Can you hear me?
Yes, sir. Good morning, sir.
What is the progress of the investigation?
Sir, now the case is pending for receipt of reply from Bharti Airtel, sir. They have given a part reply, sir. So we have again asked to give the KYC for detection of the accused, sir. And during investigation, it was seen that the money had gone to a particular account, and from there it was expended through Quicksilver Solution in Noida. So we have given 91 CRPC notice to them also, sir. But reply is yet to be received. So now we have directed the IO to visit the place, sir.
Actually, the senior superintendent, why I have asked a special investigative agency to look into the matter, taking into account that the investigation which was being carried out by the Rongya police was not adequate. In fact, the investigating officer had no clue as to
Right,
how to investigate these type of cyber crimes. So
Right, sir.
therefore, I have put it to with the hands of the special investigative agency, because you may be having a lot of other acumen to do so in this proper manner, because this is an issue which is of public interest and would have large scale ramifications, because a lot of people, and this is a case of SIM swapping, which has had resulted in all these things.
Yes,
fact,
sir. Yes, sir. Yes, sir.
It is worrying for this court to take note of that the electoral ID, the fake electoral ID, which I may say was used, is still shown in the ECI website of that person concerned, of that lady. It is still shown out there that it is a valid ECI ID. You have to look into that aspect also, because it seems that that ID would be also a fake one.
Right, sir. Right, sir. We have asked for the KYC, that's why, sir.
No, the person concerned, the lady who went to the Airtel office,
Yes.
had used an ECI ID, and on the basis thereof, she had made the SIM swapping,
Sir.
and the SIM swapping happened. Now, this
Sir.
ECI ID has now also because I could see during the time of the elections out there, it was you could trace out with this electoral ID number. It has been shown out there that it has been duly issued, which means these are also cases of fake election IDs also being prepared in that regard.
Right, sir. Your point has been taken, sir.
Yes.
Right, sir.
We can expect some progress in the investigation by when? Can you just give an indication?
Sir, by next month, sir. We have already issued notice to them, sir, for giving the KYC and other details, sir. And I have already asked the IO to personally visit the office of the Airtel and at Noida, sir. So we'll make the progress in the next month, sir.
Thank you.
Sir.
Sir, Because the Superintendent Police said that KYC has to be given update by Airtel, so I'll also inform my client.
Okay.
I'll also-
Okay. Now, what has happened to the
That-
writ
that is
appeal
listed
pending before the?
tomorrow. The writ appeal is listed tomorrow. We have
Tomorrow it has
we have tried to list and it is being listed.
And where is the SBI? Where is
RBI also filed an affidavit.
RBI has filed an affidavit. RBI has put the blame on you.
Practically the same affidavit filed by us. Practically
No,
the
they
same.
say
But
therefore,
only thing they say that the cyber crime is there. If some report comes from them, then they will decide. That is what this.
but
in their
the,
affidavit.
but from the initial investigation or the charge sheet which has been submitted, it is clear that this petitioner was duped. There's no quarrel with that thing that he was taken for a ride. In fact, he did not disclose anything except the name of his daughter as regards the when it was being asked. That is the charge sheet. So if that be so, that is already an opinion. If that is the opinion, have you taken into account that opinion also while making your affidavit? Or do you want that the criminal investigation and then a trial should go on, the trial commences, and then you will come up with a stand to the effect, oh, here, this has happened?
Transaction. I through the internet, banking is paid by UPI. All of these two are done by sharing it against. Investigation will reveal.
No, how, let me tell you, give you an example. You are saying about a UPI transaction. UPI transaction would be done how?
By sharing the OTP. OTP goes to that registered mobile number.
Absolutely. That you are aware that the mobile number was swapped. The SIM card was taken by somebody else. So the fact that the SIM card was taken by somebody else,
That's why the investigation will reveal.
that investigation has already revealed in the final report also. That has already revealed. Therefore, the question is, how is the petitioner in any manner to be blamed?
Otherwise, the bank needs to prove that guilty is on the part.
Absolutely, because if you see your clause 7 categorically mentions one very important aspect, that if it is neither the fault of the bank or of the person, then the bank would make the payment. Now, here is the case that there cannot be a mistake committed by the petitioner. Only thing the petitioner diverge is when these persons could get hold of the name of the person, the mobile number, he only said that this mobile number belongs to my daughter. On the basis thereof, they have prepared the fake ECI. And then they made the SBI SIM swapping. So under such circumstances, this is the only thing they have divulged, nothing more than that.
In terms of the notification of July 2017, we are confined whether it is on the part of the petitioner or on the part of the bank. So we are limited to that. That's why
Because
we're saying that
we are more
cybercrime will reveal more things, how it was done.
No, it is already there in the final report. I have asked them to go for a further investigation because there is a necessity, because the investigating officer was not in a position to say how the black web, how the transaction was carried out in the dark internet. So for that, we have asked the specialized investigation to carry out. But the fact that the petitioner was not at fault, it is clearly established. So under such circumstances, why the petitioner would not be getting the benefit under 7A or 7B?
Because
7B.
in this case, neither the
7A
bank
would be a
nor-
case where the petitioner diverges. Just for example, there are many cases where you find that there is a request made to your mobile number, you by yourself or your negligence, you give that number, the OTP number, and this results in a fraudulent transaction. Then obviously he may not be getting if he does not report within 4 days. But here is a case where there was no mistake. There was nothing. The SIM was taken away. Somebody else have done it. So under such circumstances, where can there be a mistake of the petitioner? The problem arises, I could have disposed it of in the, or direction here is because of the writ appeal pendings.
Mr. Lordship, agree, was that a direction that was issued in that paragraph, paragraph 29, if I'm not mistaken, and that has been in that court said state that particular 29. Specific, your Lordship was asking that. What do you say on that, whether interim period, whether the amount can be paid or not? But I have not found, very honestly, I have not found that answer which has been replied by the RBI. With
No,
that,
that is
that
the
was the
issue.
specific answer, that was your Lordship was question that was asked. That was the answer, that was the specific.
Because if you see 7.6,
Yes.
7B, 7B, 7A, 7.2. In case where the responsibility for the unauthorized electronic banking transaction lies neither with the bank. So we are not saying that the bank had made a mistake. No. Like, the SBI is not made a mistake. Nor with the customer, but lies elsewhere in the system.
That according to the third.
And when there is a delay of 4 to 7 days after receiving demand on the part of the customer in notifying the bank of such, the per transaction liability shall be limited to one which has been mentioned in table 1. Table 1 says 10,000. So again,
Yes, they stated that let the investigation complete, right? Because there is no, as your Lordship has stated, that there is no part of the petitioner as well as no part. of
no,
the bank.
no, it is not for, I have not stated that. It has been stated in the FR also. That is the final report which have already been given. Now the question is, how do you trace out these culprits? Because here this investigating, it is only certain persons who got the benefit, who got paid. If you see my order, how it happened is this. It has been categorically mentioned. You see, yes, paragraph 18 of my order passed on 28/5/2024. During the course of the hearing, this court inquired from the investigating officer as to how the investigation was carried out and what transpired therefrom. We got it? The investigating officer submitted that during the investigation, it came to light that the arrested persons accused taking the benefit that the petitioner is a senior citizen somehow managed to get the ATM debit card details as well as the ATM PIN. Thereupon, the arrested accused persons went to the CSP of a bank and obtained the mobile number in connection with the bank account of the petitioner. It also came to light that during this investigation, that these accused persons called up the petitioner and informing him that certain amount is to be deposited in his account, sought for the name of the person on whose mobile number the petitioner had put in his bank account. Upon being able to get that information from the petitioner, so the only information is whose mobile number it was. The accused persons obtained the fake electoral ID card of the same name of the petitioner's daughter and thereupon managed to get a fresh SIM by SIM swap. It also came to light during investigation that the said amounts were withdrawn in the name of Quicksilver Solution, gift card solution provider through darknet facility, and thereupon 20% of the said amount was retained by another accused person who is yet to be apprehended. It is in this regard the special investigation had to be given, and the remaining amount had been transferred to the arrested accused persons who had in the meantime already transferred the said amounts to other accounts which could not be traced. He further, upon investigation, the charge sheet had been submitted But as the person who took the 20% is yet to be aware, request has been made for further investigation. So the further investigation is only in respect to that aspect, nothing more than that.
Because that your lordship further indicated for the purpose in paragraph 21,
Yes.
last 4 lines. According, this court direct the special superintendent of police CID cyber to take up the further investigation in respect at 21, paragraph 21, last
Yes,
5 lines. And to submit a report before this court.
Because once you have the SIM, nowadays if you go anywhere, you don't require your wallet anywhere. In India, in fact, I was staying in Aizawl out there, I didn't have to open my wallet at any point of time. You have the mobile, you can do anything today. So under such circumstances, here you only need the SIM of any person whom you know and you know the account number. You can very well do anything with that SIM. Pursuant to the order dated 39/2024, Mr. Your good name, Mr. Superintendent? Mr. So-and-so, the senior
Sir,
superintendent.
I'm Sudhakar Singh, sir.
Mr. Sudhakar Singh, the senior superintendent of police CID cybercrime, is present through the video conferencing link, so provided by the state council. During the course of the interaction, this court inquired with the senior superintendent of police CID as to cybercrime, as to what is the progress of the investigation. And he duly submitted that steps have been taken by issuance of notices under section 91 of the CRPC upon various persons, including the Airtel, including the Airtel. In addition to that, he further submitted that steps also have been sought for, have also been taken as regards obtaining of the KYC of the persons concerned. The senior superintendent of police further mentioned that the investigating officer have also been directed to visit the Airtel office at Guwahati as well at Noida, so that further details can be obtained. At this stage, Mr. Didas, the learned senior counsel appearing on behalf of Airtel, had Bharti Airtel, Bharti Airtel Limited, had submitted that that his clients would provide all due informations to the investigating officer when so approached. This court have also taken note of the addition that an affidavit has been filed by the newly pleaded by the respondent number 5. Respondent number 5. It is also to be taken note of that the appeal which have been filed against the order dated 28/5/2024, that is writ appeal number 204 of 2024, is fixed tomorrow before the learned division bench of this court. This court have also inquired with the senior superintendent of police cybercrime, CID cybercrime, as to how much time would be further required for getting a better picture on the investigation. Further investigations will be carried out. The learned the officer submitted that that after 1 month a more concrete picture on the investigation can be placed before this court. Taking into account the above, this court fixes this matter again on 17th of December 2024 I think 17th of December, Mr. Singh.
Right, sir. Right, sir.
17th of December for an update as regards the further investigations so carried out. The councils appearing on behalf of the petitioner as well as the respondents shall also apprise as to what further transpired in the writ appeal being WA number 204/2024 listed tomorrow before the Learned Division bench.
Deeply appreciate.
You file a reply to that RBI. Oh, the personal appearance of the personal appearance to video conferencing link of the senior superintendent of police, CID cybercrime is dispensed with. Mr. Singh, kindly see to it that on the next date an update is placed, given to the government advocate to place before it.
Right, sir. Right, sir.
Only one, my lord. What my the Superintendent Senior Police has said, notice has been sent to Quicksilver also. That's has been sent.
I have seen
Noida. Quicksilver.
Quicksilver to Goyal.
Actually, Quicksilver is in Noida.
Noida, that's why, Quicksilver. I'm deeply aware.
First, top of the list, item 1 to 5.
Yes, Mr. Senior Counsel.
Lordship. So this writ petition, Lordship, is filed by a private limited company with writ petition number 1. They are into mining activities, and the issue involved in this case is regarding a mining plan was granted, which was revoked. The approval was revoked by Indian Bureau of Mines on certain grounds, but I will go to that in order a little bit later. Let me place the facts in seriatim. I'll also place the relevant laws which governs our case. So they have revoked our mining plan on 2-3 grounds, citing some violation of the provisions of the law. So if Lordship is pleased to come to Annexure 1, page 46.
Yes.
To get a mining lease, Lordship, there are 2 ways. One is by getting a prospecting license, and another one is that letter of intent. But we are pursuing this channel. So on 24th of February, Lordship will kindly mark the date of 2014, because there is a major change in the law in 2015, and the new rules also came in 2016. So this grant of prospecting license for graphite for an area of 14 square kilometers in Taliha in West Upper Subansiri district, Arunachal. In exercise of the power conferred under subsection 1 of section 5, the provision is there. I'll come to that provision a little later. Of the Mines and Minerals Development and Regulation Act 1957, the government of Arunachal hereby granted prospecting license for license of graphite over an area of 14 square kilometer at Taliha in West Upper Subansiri in favor of your company for a period of 3 years. Or you will note this 3 years. In accordance with the provisions of existing rules, subject to compliance of the provisions of the said Act and rules made thereunder under Forest Conservation Act 1980 and other laws in force from time to time. So the area is also demarcated with the coordinates and terms and conditions. 1, the licensee shall pay such prospecting fees as may be fixed by the state government. These are the conditions. There is no dispute regarding fulfillment of any of these conditions. We procured it. And next is Lordship will kindly mark the we have to take certain protection regarding trees, etc. Roman 9. And thereafter, a deed of prospecting license was also executed under the provisions of the then Rule 15.2, which Lordship will find at page 15. This was for a period of 3 years, and thereafter, on expiry, Lordship, we sought extension, and a renewal order was also issued at page 62 for further 2 years. On 8 August 2018,
These mining leases are in the forest area.
it can be in forest areas also.
Then whether
There are
the-
certain provisions.
whether there is the not requirement of taking permission under the forest conservation.
Those things have to be given, Lordship. These are part of the subsequent conditions. This comes much later. This is prospecting. We have to explore whether mines are actual ores are there or not, graphite.
This is for that purpose.
At that point of time, we are exploring. Or
So
you
what
will
is
call
the
it
role of a-
reconnaissance permit also. There are 2 words.
Well, what is the role of a?
Yes, let us come to
prospecting license?
section 5. Section 5, Lordship, we have it. If we have given this, Lordship, the compilation of the provisions of law. If Lordship is pleased to come to section 5.
I've appropriated a book for Mr. Didas once.
Kostov is also one of the author. Kostov
Oh,
Gogoi.
it is he. He's the author of the book.
Oh, there is another one I have gone through it. That is by Kostov Gogoi.
This is by Coastal Guru.
Okay. I think my color is different. The front page color.
This I appropriated when
No,
Mr.
no,
Didas was
same
arguing.
color.
Yes.
Yes, Lordship.
Yes.
Mukut Saiki and Kostov Gogoi. In any case, Lordship will kindly come to section 5. Restrictions on the grant of prospecting license or mining leases. The state government, number 1, the state government shall not grant a reconnaissance permit, prospecting license or mining lease to any person unless such person is an Indian citizen or a company as defined in section 2 of the Companies Act. B, satisfies all conditions as may be
And
prescribed.
prospecting license has been defined in section 3G.
Definition, Lordship, definition.
Yes. Means a license granted for the purpose of undertaking prospecting operation.
Yes,
Prospecting
is not
operations
mining.
means an undertaking for the purpose of exploring, locating and proving mineral deposits. So it is only for the purpose of finding out as to whether there are
Exactly,
Yeah.
exactly. If we find then if there is presence of this kind of mines, then only the subsequent action will take place.
Yes.
So there is no dispute. They have given us, but the date is important because there are certain situations which evolved due to the amendments in 2021 as well as of the rules. And it was given for 3 years. That Lordship will find in section 7. Period for which prospecting license may be granted or renewed, the period for which a reconnaissance permit or prospecting license may be granted shall not exceed 3 years. A prospecting license shall, if the state government is satisfied that a longer period is required to enable the licensee to complete prospecting operations, be renewed for such period as the government may specify, provided the total period should not exceed 5 years. So in 2018, I got another 2 years extension, which Lordship will find at page 62. Renewal order. So here, in exercise of the power conferred under subsection 1 of section 5 of the Mines and Minerals Act 1957, the government of Arunachal Pradesh hereby grants renewal for prospecting license of graphite of an area of 14 square kilometer in Taliha, so and so, for a period of 2 years with effect from 29th May 2017. It was given with a retrospective effect.
It was there till 28th of May 2019.
Yes, Lordship. That also has a relevance, that date also. I will come to that little bit later on. Then another renewal deed was also executed at page 67. Here also in clause 2, grant of license, the 2 years period is mentioned. In the meantime, Lordship, on 16/8/2019, that date, Lordship may have kindly note, 16th August 2019, we have applied for
So
a mining lease.
this is after the expiry of your prospecting license.
Yes, but within 3 months, we have to do it. We have to apply.
So your prospecting license was
In May 2019, it expired.
19. So you did it within 3 months.
As per the rules. We'll come to the rules, Lordship, but within 3 months we have to do. And therefore, when it was filed on 16th of August 2019, it was well within time. This is to bring a notice that we are submitting mining lease application along with geological report, forest map, mining lease area map, treasury challan, board resolution for authorized signatory, etc. You may kindly grant us the mining lease for Taliha. So this was the application we submitted along with next page. Lordship will kindly see the provisions is under Rule 7. 7.1. Lordship will also mark this because there are 2 channels of getting the mining lease. One is letter of intent, the other one is through this prospecting license. So we have applied it under Rule 7.1.
You are referring to the 2017 rules.
2016 rules. Rights of a holder of a prospecting license to obtain mining lease. 7.1 says,
What is the name of the rules?
rule is called, Lordship, 2016 concession rules. There's a in between within bracket, there's a name which, yes. Lordship, it is called minerals within bracket other than atomic and hydrocarbons energy minerals bracket close concession rules 2016. So basically it is mining minerals concession rule, MCR.
Where is that?
Seven one. So those who are, because one of the line of the argument of the other side that it was given letter of intent wise. No, we are not on that. We are on 7.1 because I was holding a prospecting license or reconnaissance permit. So 7.1 says, have Lordship got rights of a holder of a prospecting license to obtain a mining lease. The holder of a prospecting license granted prior to, this date is also important, prior to January 12, 2015. Ours was of 2014. Or pursuant to Rule 5 may upon fulfillment of the conditions specified in subclause 1 to subclause 4 of clause B of section 2 of 10A, that I'll also place your Lordship, makes an application to the state government for grant of mining lease in the format specified in Schedule 6 within a period of 3 months from the after the expiry of the prospecting license or within such further time not exceeding 6 months as may be extended by the state government.
So you have done within on 16
3
days.
months. Not, we are not paying for that extension also. So I'm going back to the repetition now.
And page 74 is the acknowledgement.
Acknowledgement, Lordship. Lordship will kindly see rule now. Lordship is keeping Rule 7.2. The state government shall send an acknowledgement of receipt of the application submitted under sub rule 1 to the applicant in Schedule 2 within a period of 3 days of receipt of the application. So 1 is fulfilled, 2 is fulfilled.
And the state of Arunachal was very prompt
Yes,
to
sir.
give it on that
Very
very
promptly.
dates.
Yes, sir. He is there.
Very prompt to give it on the very day. Yes, then the letter of intent comes.
letter of intent, actually it was not required, but they have issued it, rightly or wrongly. In fact, I would say it is not, because our application is on a totally different thing. 7.1. Because a person who is not having a this prospecting license, to them, by letter of intent, they can issue the mining lease. That is the second provision. I'll come to that. But our case is very clear that we have applied and we have obtained the prospecting license before 2015, and it was duly renewed also by the government of Arunachal. And we have submitted the application for mining lease under 7.1, which says right of a holder of a prospecting license to obtain a mining lease, not letter of intent. Rule 8, Lordship will see, there is a separate provision. The event is different totally. Rule 8 says, right of the provisions of clause C of subsection 2 of 10A, which will ultimately take to the A says the state government has issued a letter of intent. So here the letter of intent is basically redundant, absolutely has no meaning. And here also A says the state government has issued a letter of intent by whatever name called in writing before 12 January 2015. Before this letter of intent, which they have issued in 2019. So it has absolutely no purpose at all for the issue which is involved in this writ petition. This date is very important.
Yes, then
So they have misread the law without any purpose. They have issued it, but we are not harping any reliance, or we are not giving any emphasis on this. Yes. See, we are submitting the provisions of the law in a compilation that will. Subsequently, I will give the page numbers shortly whenever I refer to any statutory provision. So this letter of intent was issued on 21st of August 2019. In my humble submission, we can simply ignore it because it has no meaning for the purpose of issuance of mining plan or for the purpose of issuance of mining plan lease. So this is a redundant exercise they have done, and we are not taking any advantage of that also. Rather, they want to take advantage of a document which has no relevance under the statutory rules. The rules are framed under Section 13 of the MMDR Act as amended in 2015. Now coming to page 76, 25th January 2021, we have submitted the mining plan to the IBM. Sorry, I'm sorry, Lordship. Yes.
76 is the amount deposited.
Yes, 24. This is submission of mining plan along with all maps and sections, instrumental, so and so to the government, Department of Geology and Mining. This has some meaning which will come under 5.2 proviso. Now, this 25th, we have submitted a mining plan to the government of Arunachal. Their department, concerned department is the Department of Geology and Mining.
What do you say about 78?
Is 78, 25th January, there is a request made to them for execution of a mining lease of Taliha.
On the basis of the letter of intent.
The letter of intent is issued, but it has also, because this cannot be done. This also cannot be done. This deed, as well as a letter of intent I am abandoning. This deed also cannot be executed under the rules. It has to be done after completion of all the formalities as indicated in Rule 7, sub-rule 10. If Lordship will kindly come to Rule 11 now. I'll go back again, but for the time being, to clarify Lordship's query. The state government shall lot of activities has to be done in terms of 1 to 9, then at 11, 1 to 10, the state government shall execute a mining lease deed with the application of the format specified in so and so within 90 days of fulfillment of the conditions specified in sub-rule 10. Sub-rule 10 is previous. There are certain requirements. Then only, Lordship, the deed has to be executed. So that deed, now they have recalled it. There is another litigation. Lordship had set aside that cancellation also. It is now remanded back to the Arunachal government. It is pending.
So in fact, that is infructuous.
More or less, that is why this letter of intent and this deed, mining lease deed, has no meaning for the purpose of the instant case.
So the setting aside of the mining lease which was done without hearing you.
No, but the mining lease deed was, the grant of mining lease was not cancelled till today. There are difference. What they have done today, IBM has revoked the approval given to the mining plan. That is the subject matter of the instant writ proceedings. Number two, the Arunachal government on their own, without giving the principle, following the principle of natural justice, cancel the mining lease deed provisional, which was also a provisional one. Lordship set aside that cancellation and remanded the matter back to the Arunachal government, which is now pending adjudication at their level. My whole case is, let me clarify it once more, that it is not on the basis of that mining lease deed or the letter of intent. My whole case is on the basis of the protecting license given to me in 2014, extended in 2018 with a retrospective effect of 2017 to May 2019. And I have applied under 7.1 the mining plan, mining lease, which they have granted, and till date that is not being touched.
So in that case, this has to be done, the rights of a holder of a prospecting license to obtain a mining lease.
Lease, I have obtained it. Mining lease I have obtained, but the mining lease deed, that has to be executed after, let us come to 7.6. Lordship will 7.6. Let us come to 7.6. The state government shall, on being satisfied that the conditions specified in subclause 1 to subclause 4 of clause B of subsection 2 of section 10A have been complied with within a period of 60 days from the date of receipt of the duly completed application, communicated to a order of its decision to grant the mining lease to grant of mining lease, not mining lease deed here. So Lordship will kindly take the emphasis of grant, the word of grant. So that grant has been given to me. And to that factual aspect, I'll just proceeding now. A decision to grant the mining lease for a mineral other than those specified in first schedule of that to the act. Lordship will kindly come to page 86 now. This is till date, it has remained intact. May I read it, Lordship?
Which one?
29 January 2021, page 86 of the writ petition. Have Lordship got it? Page 86.
So for Part C mining, for the state government has to forward to the central government for its previous approval for grant of mining lease for
We
any
don't fall into
mineral.
that category.
Huh?
We don't fall into that category.
What are you asking for?
Ours is graphite. In schedule 1. Graphite. Sorry, not in schedule 1. Yes, it is here. That schedule will make us know.
Graphite is where? It doesn't fall in ABC.
Ours is page 53. Lordship will kindly see the graphite 22 serial number.
Huh?
In schedule, second schedule, under section 9.
So 6, how do you say about 6 have any application? 6 only refers to first.
I am not getting Lordship's query.
In 6, it says
Rule
how
6?
the application is to be made.
Yes.
What will the state government do? 7(6).
7(6) says the state government shall, on being satisfied that the conditions specified in subclause 1 to subclause 4 of clause B of subsection 2 of 10A. Let us go to 10A.
Okay, have been complied with
Yes.
within a period of 60 days
Yes.
from the date of receipt of the duly completed application. Communicate through an order its decision to grant the mining lease for any mineral other than those specified in the
Other than.
first.
So we are in schedule 2.
So they come under rule 7(6)(a)
Yes.
because of the fact that graphite falls in
Schedule 2.
schedule 2.
So other than. So the state government is empowered
To do it.
under
So you don't
7(6).
need the central government.
We don't need central government's approval. So that is why page 86 Lordship will kindly come. 29 January 2021.
Yes.
In exercise of the power conferred by subsection 2 of section 5 of the Mines and Minerals Development and Regulation Act 1957, the government of Arunachal hereby grants, Lordship will kindly mark this word grants, the mining lease for graphite over an area of so and so for a period of 50 years, that is the maximum period permissible, in accordance with the provisions of existing rules, subject to compliance of the provisions of the said act, that means the same MMDR Act, the rules made thereunder, including Forest Conservation Act, which Lordship was putting that query, we have to follow subsequently. 1980 and other laws in force from time to time, the coordinates are given below. Next is, Lordship will kindly see page 87, terms and conditions. The grant of mining lease is subject to the following conditions. Condition number 1, the mining lease holder shall obtain environment clearance from the state government, the State Environment Impact Assessment Authority, that is SIA, or from the Government of India. If it is a community non-forest land, then consent from the community and local landowners should be obtained. So in Arunachal, that is also very relevant, even in Meghalaya. So that we have to obtain the EC from the state government, State Environment Impact Assessment Authority, as well as from the Government of India. 2, the mining lease holder shall obtain all consents approval. Lordship will kindly mark this word approval here. We got the approval and that approval has been revoked. That is a subject matter. The mining lease holder shall obtain all consents, approval, permit, no objection as may be required under applicable laws from the concerned authorities before the commencement of the mining operation. This grant of mining lease is not sufficient to allow me to go and start the operation. I have to fulfill lot of other conditions. Then only I can operate, including I have to execute a deed.
This clause 2.
Yes, it is mentioned.
Is in consonance with Rule 710A.
These are directly copy paste from that. 3. Shall provide a performance security to the state government as prescribed under subclause to under clause 10 of Rule 7. Other than says 2000 after compliance of above condition mentioned in paragraph 1 and 2 before commencement of the mining condition operations. So 3 also is very clear. Sign a mine development and production agreement with the state government as per the format specified by the central government after compliance of conditions specified in para 1, 2, and 3.
This has not been done.
That is why we are not starting the operations also. Yes.
Yes.
After number 5, after compliance of conditions specified above para 1, 2, 3, and 4, every mining lease shall be subject to the following conditions as per Rule 12 of the Mining Concession Rules 2016. Here, C is relevant. Other royalty, etc., we have to give. C says the lessee shall commence mining operations within 3 years from the date of execution of the lease and shall thereafter conduct such operations in a proper, skillful, and workmanlike manner. So once we execute the deed, and before executing the deed, we have to obtain all consents, approval, permits, no objection, etc. Whatever is there indicated in Rule 17.
Now here it is given 3 years, but here it is given 12C says 2 years.
Well,
You see the rule 12C,
just one second.
this is from the execution of the lease deed.
Yes.
Now here lease deed has not been executed.
Here, no.
No lease
No.
deed. So 12C,
Under this, under the present channel, lordship, no.
and where have you found out this 3 years aspect?
3.
You see, well, the lessee shall do it within 3 years. Just now you read it.
So whatever the rule says, suppose it is 2 years and that is not the issue, but whatever the rule says, there is a conflict.
Now, this will only happen because the rule says that it will 2 years is from the date of execution of the lease deed, mining
Absolutely.
lease.
Yes.
Here there is no mining lease deed executed.
No. So far as the present system is concerned. The lease deed which was executed, which has no meaning, it was sort of a provisional. I can show it from the language also. All the things are in future tense there. Please. Page 98.
Now, are you saying that there is no requirement of a mining lease?
What they are saying, lordship, they are saying that we did not have an approved mining plan. That is number 1. Number 2, they say that under the 2021 amendment, lordship, our case has got lapsed. Pending cases, certain cases are lapsing, but our case do not fall into that category. From their reasons and objects of the Amendment Act, I'll try to satisfy this honorable court.
But there is a mining lease deed.
Grant is there.
No, mining lease deed. What is that, page 98?
That was a provisional. In fact, on the same date, lordship will kindly mark this, lordship. 29 January and page 86, 29 January. Same day, all these formalities cannot be done. Therefore, it was sort of a provisional. At best, we can say it was a sort of a provisional mining lease deed.
But is it written to be provisional?
Page 100, paragraph 3, lordship will see. All are in future tense. Lease deed has to be executed after completion of all the actions which are contemplated in Rule 7, Sub-Rule 10. This is sort of a provisional. In fact, there is no statutory presence of this requirement.
But here, what do you say at page 100, 2.1? The state government hereby grants the lease to the lessee over an area described in B for conducting mining operations for a period of 50 years
Yes,
from the date on which this duly executed mining lease is registered with respect to graphite. So it is registered on very date
the Lordship will kindly
on
come to
29th
three
of
now.
January.
3. The rights and obligations of the state government and lessee shall be as specified in the act and the rules made thereunder, including without limitation to the minerals concession of 2015, without prejudice to the general purpose. The lessee shall obtain environment clearance from state government, state environment impact assessment, etc., etc. All the requirements, Lordship, consent. 2 says, Roman 2 says that mining lease holder shall obtain consent, approval, permit, no objection, as may be required under applicable laws from the concerned authorities before the commencement of the mining operation. It's a verbatim reproduction of 710, and now 711 says, what 711 says? That is very relevant. Therefore, this deed has no meaning at all. In fact, nobody took any advantage of this deed. We are not paying at any stage for invocation of any of the clauses of this deed.
No, this is being done in terms with 711 only, this mining lease.
You kindly see. It's devious from the
No,
number one.
just for example, being a civil bench one judge, I'm saying,
Lord,
we go for a lease deed out here that this, the lessee shall every month pay, English calendar month on, pay their rent. Would you say that the lease has not operated? It is operational.
but here, even the lease is there, lease deed. Nobody is taking advantage of this, or nobody has a disadvantageous position also. So, in my humble
But this is a
submission,
lease deed in terms with 711.
711, but it should not have been done by Arunachal government.
Why?
Basically, it's a conditional one. It is not, if Lordship will kindly look at the language of 11. The state government shall, because till that moment when the lease grant was given to us, as well as execution of the provisional lease deed, we did not have the approved mining plan also.
Yes. See, it is exactly, this lease deed is exactly in terms with schedule 7,
Lordship,
page
What I am
116.
trying to emphasize here is, Lordship, conditions are different, Lordship.
No.
It-
It is same.
If Lordship comes to page 117. 117.
The lessee shall at all times comply with the provisions of the act and the rules made therein under, make prompt payment of royalties, pay such compensation as may be assessed, take measures at its own expense without delay, send to the deputy commissioner a report, weigh, submit to the Iman a full report of the work done. State government shall have the right at all times. These are all these clauses which are there.
3.2, there are
Kindly
deviations
come to page 102
from
of
100.
the writ petition B. And kindly see 118. It is
Two
verbatim same.
sentences may tally, but the major areas, there is a deviation.
They have put some more additional details how it happened. But here, this is a mining lease. Anyway, then,
But if we go by 711 Lordship,
hmm,
the 711 says, after you complete all the requirements, fulfill all the requirements, then only the final lease deed can be executed. And this lease deed is on the same day. When?
so you mean to say without completion of the
Formality.
formalities under 710, the mining lease deed could not have been there.
Yes.
Okay, then,
That is Therefore, we are not harping on that, but we are placing all the facts reports. So page 86.
So you mean to say that the deed of mining lease which was issued could not have been issued?
No. A grant of lease can be issued.
No,
They-
grant of lease is a different thing.
Yes.
But a grant of mining lease could not have been executed unless there is a
Mining
compliance.
deed, it cannot be executed without
Unless there is a
fulfilling all the
compliance-
requirements.
Compliance with 17.
17. This was wrongly done. Although they have realized their mistake, they have taken an action without fulfilling all the other requirements of law, and therefore this honorable court was pleased to set aside that. So now coming to page 86, one more, page 87.
I set aside because they have sent it by simple post.
Thoughts?
They have sent so-called notice by simple post. And they wanted this court to deem, which is completely contrary to the General Clauses Act.
Not.
And there being just 1 day delay in uploading, the council out here makes a mention that there is a delay. Yes. Didn't he mention it? Then the next day, it was before the similar thing happened before the Chief Justice of India. And the Chief Justice of India said that the council could not have mentioned it in this manner. I understand there may be some other courts where there might have been delays a lot in the orders being uploaded, but this had only taken 1 day. It was delivered on Thursday, I suppose. And Friday was closed. Saturday was closed. Sunday was closed. Monday, it was not uploaded at 10:30 in the morning, so mentioned.
Yes. So page 87, Lordship, I'm taking. The mining lease is subject to the following conditions. 1 and 2 I have placed. 3, we have to give the providers performance security. And 5C.
So you therefore say that the mining lease remains, but there is no execution of a deed of the execution of the lease, mining lease deed could not have been done.
Yes. Grant has been given to me. And after the grant has been given, I have to apply and fulfill lot of formalities, including MOEF clearance, the CS clearance, other consents, and on top of that, the mining plan from IBM.
Now let
That approval I have to get. And therefore, the word is said approval.
and thereafter
17
what has
C.
happened?
Seven 10 says, upon issuance of the, Lordship will kindly mark this word upon. The impugn order was issued, complete misreading of this. So once I got this order of 29 January 2021, whereby the Arunachal government was pleased to grant the mining lease to me for graphite for 50 years. So I have to fulfill the requirements as indicated in the terms and conditions of the said communication of 29 January at page 87.
Yes.
Which is, and also Lordship will kindly come to page 89, serial number 9, N.
Yes.
The lessee shall comply with the provisions of the act and the rules made thereunder, including the rules made under section 18, it should be 13. So we have to do whatever is prescribed in the rules.
Okay.
And the rules very clearly prescribes.
So you therefore say that without the requirements under 710 being complied with, the mining lease deed could not have been at all executed. Because it categorically says in 11, within 90 days of fulfillment of the conditions specified in subrule 10. So 10 having not yet been completed,
Yes.
this could not have been.
Yes.
So this document is absolutely.
Absolutely not.
have no-
That is why I'm saying that the letter of intent, that these two documents has no purposeful meaning in the present activity.
Now thereafter you have obtained the mining plan.
mining plan we have obtained. That
Which is-
I'll come, Lord.
which
Little
is
bit later.
205. Let's
Let's-
come to 205.
205. Now, before that also, Lordship, how we applied and how they apply, put their application of mine, Lordship, that also has some bearing in the instant case. Because all of a sudden they have issued the revocation, but prior to grant of approval, Lordship, what exercise they have done? We have submitted the mining plan. So, just one second. Lordship will kindly come to page 97. In terms of that, we have submitted the sub challan also on 29. We can skip all this. Now coming to mining plan, page 159. So we have submitted. Lordship will kindly see annexer P17. The senior mining geologist for regional controller of mines, Indian Bureau of Mines, issued this receipt on 2nd of March 2021. Received 2 copies of draft mining plans containing 76 pages, 16 annexures, 25 plates, along with the following particulars for approval under 16.1 of the mining MCR 2016, Rule 23 of the MMDR Act 2017. So we have submitted our mining plan for approval on 2nd of March 2021, and thereafter on 18/3, they wrote to us, inspection of your Tahila graphite deposit over an area of so-and-so in Upper Subansiri by virtue of the powers conferred under section 24(1) of the Minerals and Mines Amendment Act 2015. I propose to inspect your above said applied area on dated 23rd March 2021 and 24 in connection with mining plan with PCMP submitted to this office on 26th February. It is therefore requested to remain present on the said 2 dates. And the list of persons were also given. And after the inspection, they have done the inspection in our presence. Lordship will kindly come to page 178. On 20th of May 2021, they issued a provisional approval. The first they have issued the provisional approval. Subject, provisional approval of the mining plan along with progressive mine closure plan in respect of your Taliha graphite deposit, so-and-so, your later dated so-and-so, in exercise of the power under clause B of subsection 2 of section 5 of the Mines and Minerals Development Act 1957, read with Government of India's order dated 28 April to 1987, dated 18 May 2016. The competent authority directive issues later dated so-and-so. I hereby provisionally approve the above said mining plan along with progressive mine closure plan for the period 2021 to 24-25 in respect of so-and-so. Then they mention about the conditions, they mention about the lockout, etc. Number 2, that the final approval shall be based on examination of the submitted final cross copies of mining plan, which shall be correct and complete in all respects with respect to the scrutiny issued and compliance of other statutory provisions, failing which provisional approval shall be revoked. The mining plan is provisionally approved without prejudice to any other laws applicable to the mine lease area from time to time, whether made by the central government, state government, or any other authority. 4, the provisional approval of the mining plan does not in any way imply the approval of the government in terms of other provisions of Mines and Minerals Act 1957 and the Minerals Concession Rules 2016 and any other laws including Forest Conservation Act 1980, Environment Protection Act 1986 and rules made thereunder, Mining Act 1952 rules, etc. The mining plan is provisionally approved without prejudice to other orders and directions from any court of competent jurisdiction. Now, there are other conditions also given, and thereafter, on 6th of July 2021, they issued another communication to us on the basis of their inspection done by their team. Lordship will kindly come, this annexure 24. Page 180. This is
Mr.
very important.
Advocate General,
Lordship.
see, kindly come to page 207. We are concerned with the impugned order.
Yes,
The impugned order says about two aspects. First, there could not have been a mining lease deed executed without compliance to section rule 710
yes,
C,
yes,
which you are also in agreement.
yes. I have no objection to that part.
It is only in the case of the second part
Second
of
part.
that order.
Yes.
In the kindly come to form further.
Yes,
This is the portion where
the
it
portion
is the
which is
difficulty.
actually-
Let us see from here and
Yes.
then analyze with the others.
yes.
Right. Kindly come to here from here. Further, this is to
Further, this
inform.
is to inform that the Mine and Minerals Development and Regulation Amendment Act of 2021 come into force by ministries so and so gazette notification dated 28 March as per section 13 of the Mines and Mineral Development Amendment Act 2021, in which section 10A 2B of MMDR Act is amended and as per amended Act 2021. The cases covered under this clause includes the pending cases, the right to obtain a prospecting license followed by a mining lease or a mining lease as the case may be, shall lapse on the date of commencement of the MMDR Amendment Act of 2021. My case will not fall into this. I'll satisfy this honorable
So
court.
your case is only in respect to this.
Absolutely.
Because
they have-
you already agree that there could not have been a mining lease
There
deed.
are two parts, Lordship.
Yes.
So far as first part is concerned, and as well as the second part, they have no business, they have no jurisdiction. How can I executed a deed with Arunachal government, an agency whose primary role is to see whether the mining plan is as per the provisions of law or not. They have no business to come and interfere with a communication or with an action between a private party and the government of Arunachal. They are overstepping, which they cannot do.
Or at best,
That is a technical body. They have no business. Had it been set aside by the Arunachal government, I can understand. And as per the second part also, they have revoked the approval. Whether they have that power to revoke? Is there any misrepresentation? Is they covered under section 19 of the MMDR Act? Mining plan is not covered under section 19. Let Lordship take the break. I'm going back to the mining plan part, Lordship. (180). So after their inspection, Lordship, page 180, on 6th of July 2021, a communication was received by us from them. Please refer to a letter and subject and submitting mining plan along with progressive closure plan in respect of Tahila or Arunachal submitted under Rule 16(1) of MCR 2016 has been examined by this office on the basis of site inspection done on 23rd and 24th March 2021 by Vikas Kumar. The scrutiny comments made by the submitted mining plan along with progressive mining closure are enclosed herewith. In this regard, you are advised to rectify the deficiencies. Lordship will kindly mark this. So they have found some shortfalls. So they have advised to rectify the deficiency and submit final 3 hard copies within so and so with all the strings. The parawise clarification indicating the manner in which the deficiencies have been attended should invariably be given while submitting the mining plan. No further extension of time in this regard will be entertained and the documents will be considered for rejection if not submitted within the above due date and deficiencies not attended properly. So they examined everything and applied their mind. And next page, Lordship, they have given total number of up from that page up to page 187, 84 numbers of shortfalls where we have to comply. From page 181 to page 187. So these are the scrutiny committee comments they have given, and we have to give parawise comments to their opinions. And thereafter on 16/7/2021, page 188, we have through CSIR, Central Institute of Mining and Fuel Research, Dhanbad. So we have, this is a central government agency. So that regarding the compliance, we have submitted our report. Subject compliance of scrutiny comments on draft mining plan along with progressive mine closure plan in respect of Tahila, Upper Subansiri under Rule 16. In response, sir, this was given to them. The next page, Lordship will see that in folded part, all comments are given of regarding 84 number of opinions, along with whatever views we have to give, we submitted. Then on 12th of August 2021, page 205. Because they are relying to this also certain conditions. Lordship will kindly see subject approval of mining plan. So approval of mining plan along with progressive mine closure in respect of Tahila graphite deposit over an area of 496 hectares in Subansiri, Upper Subansiri, Arunachal. In exercise of power under clause B of section 2 of 5 of the Mines and Minerals Development Act 1957, read with so and so, I hereby approve the above mining plan along with the progressive plan closure. This approval is subject to the following conditions. Number one, the mining plan is approved without prejudice to any other laws applicable to the mine/area from time to time, whether made by the central government, state government, or any other authority, and without prejudice to any other order or discretion from any court of competent jurisdiction. So first is that approval is given without prejudice to any other laws. Other laws here, Lordship, would be laws other than MMDR law and the acts and the rules. Number two, the proposal shown to the plates, etc. This is also not relevant. Lordship will kindly come to clause number 5. At any stage, if it is observed that the information furnished, data incorporated in the documents are incorrect or misrepresented facts, the approval of the document shall be revoked with immediate effect. So they have a right to revoke it, Lordship, if they find that some incorrect facts were given or misrepresentation is done by us. So there is no such allegation till date. I do not know what will happen tomorrow. And 6, if this approval conflicts with any other law or court order, direction under any statute, it shall be revoked immediately. The approval is restricted in respect of proposal given in the document for a period of 5 financial years from the execution lease. The approval of mining operation and associate are restricted to mining lease area only, etc., etc. These are not very relevant for the instant dispute. So here, Lordship will kindly mark clause number 1, 5, and 6.
What about 9?
9, a copy of EAI, EMP as approved by MOAF shall be submitted to IBM within 1 month of its approval along with a copy of their approval letter.
Have you done that?
So once that approval is given to us within 1 month, we have to submit.
So it has
It
to
is
be
pending.
given from 12A. I mean, 13.9 you have to give it. 13.8.
That approval we have not received till now from MOEF.
Then what happens to this approval?
From date of approval.
You see, a copy, this approval
They
is
are not-
already given.
They have not referred to this also. Our understanding is that it is regarding that MOEF's approval regarding the ECA and EAI. Within 1 month, we have to submit it to them. And they are also not relying upon 9.
Understood, but this approval is subject to this. Because if you see, 12A.
12A.
Yeah. This approval is subject to the following conditions. Amongst the various conditions, 9 says you are to give the EII AEMP as approved by the Ministry of Iman shall be submitted to the IBM within 1 month of its approval along with the copy of the approval letter.
Of its approval along with the copy of the approval letter. Of its means the approval of the MOEF.
Yes, along with the copy of the
Approval.
their approval letter. So that approval of the MOEF has to be submitted to the IBM. Have you
So
done that?
whatever we have received from MOEF, we have to submit it within 1 month.
Have you done that?
No, we are not on that. We have not. Our EC is still pending. So we are not going for operations still now. Our operation will start once we fulfill all the conditions as given in Rule 7, Sub Rule 6
No,
and Sub Rule 10.
but Mr. The approval was subject to certain conditions.
Yes.
Amongst the conditions, one condition is also to submit the approval of the MOEF within 1 month.
1 month of that approval. We have applied to MOEF. Lordship will again read it. May I read it, Lordship? A copy of EI, that means Environment Impact Assessment.
Within 1 month of each approval along with the cover. So approval of the MOEF.
Approval by MOEF.
So that you have not done because you
Yes.
have not received.
So we are not going for operations straightway now. So therefore, rightly, they have also not indicated serial numbers 9 in their impugned order. They have referred to 6 and 1. 6 and 1, they have referred to. So these two conditions, according to them, we have violated. But I'm clearing it once more, Lordship, that this approval, once we get it, we have to submit it within 1 month.
That I understand. It is only based upon after getting the approval letter within 1 month of that approval letter.
We have to give it. And once we clear all the formalities, then we have to execute the deed. Then within 2 years, we have to start the operation. At one point, it is said 3 years. At one, the statute says 2 years. So we have to go by the statute, not by the other documents given by the government.
But issue involved with page 208 from further this.
Yes.
Because the earlier part is redundant. That has no relevance because the
Okay.
mining lease deed could not have been executed in view of non-compliance with section
We
10.
have also wrongly executed. They have also wrongly imposed that action on us. And on the same day, it cannot be because the grant of lease was given on 29.
So
There are a lot of activities we have.
where do we find this letter of 13/4/2021?
Yes, Lordship.
208 13/4/2021.
In the light of notification issued by there. Now let us now look at the impugned order part, Lordship. That part from further. Further, this is to inform that the Mine and Minerals Development Regulation Amendment Act 2020. Let me place the statute first, then I'll come to.
Yes.
If Lordship is pleased to take that compilation of the provisions of law, page 14, 1/4. In the beginning, I have already said, but once more I am placing it. Section 5. Restrictions on the grant of prospecting license or mining leases. The state government shall not grant a reconnaissance permit prospecting mining lease to any person unless such person. So there is no dispute on this. Now coming to page 23, section 10. 10A. This is an amendment of 2015. A. Right of existing concession holders and applicants. So we fall into that concession holder
You
because
are coming to which?
section 10A, page
Oh.
23.
Wait, I have to see from here.
Right
have,
of
it is blank here. Yes.
10A, that is a new amended part,
This was brought in 2015.
15, Lordship. The precise date is 12 January 2015. All applications received prior to the date of commencement of the Mines and Mineral Development Amendment Act 2015 shall become eligible. So we do not fall into this. Ineligible. So we do not fall into this. 10.1. We come to 10.2. Without prejudice to subsection 1, the following shall remain eligible and from the date of commencement of the Mines and Minerals Development Amendment Act 2015, application received under section 11A, that is regarding coal. So we are not concerned about that. B, before the commencement of the Mines and Minerals Development Regulation Amendment Act 2015, a reconnaissance permit or prospecting license has been granted in respect of any land or any mineral permit holder or the licensee shall have a right for obtaining a prospecting license following a mining lease or a mining lease as the case may be in respect of that mineral in that land if the state government is satisfied that the permit holder of or the licensee as the case may be. Pausing here for a moment, we fall into the first category because our prospecting license was of 2014. At the very beginning, Annexure A, I have placed. So we fall into that. Therefore, my application can be considered. I do not fall into the category of 10A1. So I become under, I am having the right of existing concession holder. And I am saved. Now, what are the conditions have to be fulfilled? There are 4 conditions. Lordship will kindly mark this. First condition, has undertaken reconnaissance operation or prospecting operations as the case may be to establish the existence of mineral contents in such land in accordance with such parameters as may be prescribed by the central government. So I fulfill this. Has not committed any breach of the terms and conditions of the reconnaissance permit or the prospecting license. There is no such allegation of any violation. Has not become ineligible under the provisions of this act means 10A1. So I do not fall into that. And D, has not failed to apply for a grant of prospecting license or mineral license as the
Within
case may
the
be.
3 months.
Within
Now
3
you
months.
did
So,
it on 16.
I fulfill all these 4 conditions, and if these 4 conditions are fulfilled, I am entitled to give.
Let's see, there are 2 provisos, provided that for the cases covered under this clause, including pending cases, the right to obtain a prospecting license made by mining lease or a mining lease as the case may be shall lapse on the date of commencement of
Page 1. Under the amendment, Lordship,
here.
page 149. Yes, here section 13. Yes.
No, the proviso which was brought in
Yes, proviso which they have brought in,
2020.
page 153,
Yeah.
down. Provided that for the cases covered under this clause, including the pending cases, the right to obtaining a prospecting license followed by a mining lease, that means pending cases to obtain a prospecting license or a mining lease as the case may be, shall lapse on the date of commencement of the Mines and Minerals Amendment Act of 2021. So my case was not pending to get a prospecting license. Because my grant was already given on 29th of January 2021. To clarify, to get clarification, Lordship will kindly come to page 147. The statement and objects of that amendment act of the compilation. Page 147. 4. Have brought.
Yes.
Lordship will kindly up. The Mines and Minerals Development Amendment Bill 2021 inter alia provides for the following, namely Roman 4, Roman 6. To close the pending cases of non-auction concession holders which have not resulted in grant of mining lease. So I have already obtained this. So my case is not falling into the 2 other categories where there is a pending case for grant of prospecting license or grant of the mining lease. So my case is that I have already got the grant. So yes. And this has come on 28 March 2021. It's a notification.
This is prior to your mining lease coming into.
My mining lease now. Grant was given by Arunachal government on 29th of January.
Oh.
And this
29
amendment came into force on 28th of March 2021. I am safe by hardly few days, more than 1 month. So may I just read once more the Roman 6?
So now it is in this, on the basis of this proviso, they have come with that notification of 13/4/2021. Where is that notification?
That notification my friend will have to produce.
No, you must be having, without that, how can this court look into it? This is your notification on the basis of which it was done.
The notification.
In the light of the notification and directions issued by the chief controller, this is why he analyzed this proviso to section 10A2B.
10A2B, I'll come, Lordship. I have not.
No, that is
Yes.
what we are reading.
Yes.
10 capital A2B, we are
The
reading.
four
There
conditions.
is the first proviso. The first proviso seemed to have been explained in a notification dated 13/4/2021. Kindly see this, your impugn order.
It's a later part. In any case, Lordship will kindly come to page 149. The date of this coming into force is 28 March.
No, there's a difference in the phraseology used in the proviso, the first proviso to section 10(2)B. Wait, what is being mentioned in the notification dated 13/4/2021? 13/4/2021. 13/4/2021. Kindly see the impugn order.
13/4, which is also much later.
Let's see. So here they refer it. If you see the first proviso say the right to obtain a prospecting license followed by a mining lease or so and so as the case may be have shall lapse on the date of so and so. Now your case is that you have already obtained the mining lease.
Mining grant. Yes, mining lease.
Mining lease
Mining-
you have already
Grant or
obtained.
mining lease.
It is only the question that there has been the execution was made of a mining deed, but that could not have been done in view of the non-compliance to 710.
Yes.
That is okay. However, if you see the impugn order, they are relying on a notification dated 13/4/2021, wherein they use the word executed. Now, the moment a word is used as executed, it has to mean
Lordship will
the-
kindly see, this is a direction. It is not a notification. It is a direction issued by the chief controller of mines.
the
It's a
notification
letter
and there
dated
is issued by
14
the case in which mining lease has not been executed before the date of commencement of the MMDR Amendment Act, that is so and so, the mining plan approved by the so and so issued for so and so mining lease failing under safe cases erstwhile so and so have become infructuous. Now what he is doing because of this notification, as you have not executed, he says that first of all, first part says there could not have been a proper mining lease deed executed because there is no compliance to 710. Now he therefore comes up and says that this mining lease deed is bad. Can you see how the impugn order is progressing? First he says there could not have been a mining lease deed executed because there is no compliance to rule 710. This is the first part.
Yes.
Then he comes up and says that as this mining lease deed is
Yes.
bad.
Now, my whole case is like this. Lordship will kindly read the whole paragraph. May I read it, Lordship? In the light of above notification and directions issued by the Chief Controller of Mines IBM dated 13th April 2021, the case in which mining lease has not been executed before the commencement of the MMDR amendment of 2021, that is 28 March, the mining plan approved by this office based on LOI. My case is not on LOI. My case is on the other one, that protecting license. So this is applicable to LOI. I do not have any access to this letter, number one. And number two, I do not fall into this category. My application before them, as well as to the Arunachal government, was on the basis of the protecting license issued by them in 2014, renewed subsequently in 2018. So there are two channels. One channel is through LOI, the other channel is through the protecting license. So I am a concession holder. LOI is from a different channel. I do not fall into that category. Although they have wrongly issued, but I have not pursued that and they have also not pursued that.
No, it is not that you have not pursued it, you have pursued it, but the fact
We
is
have
that
abandoned it.
you have now felt it necessary to abandon it.
Now-
But the question is, Mr. Mr. Sekia, kindly appreciate what he has done, which I can find on what I need to say. He has given an interpretation to the proviso, first proviso to section 10(2)(a), 10(a) to B. On the basis of a notification dated 13/4/2021.
This is not a notification, it's a letter.
Here it says in the light of the above notification. and
Above
direction-
notification, that is above. The above is
Maybe-
different.
Maybe let us take it
And the direction issued by the letter.
on the basis of some communication issued by so and so. He has given an interpretation to that. Now, whether that interpretation is proper or not,
Yes.
taking into account the proviso to section 2, 10(a) to B,
Yes,
is the question.
I fully agree, Lordship. Number one, that letter, it does not have any statutory value. That can be internal communication between the two officers. I do not know what is there and I am not privy to that. Of course, we can apply to RTI. That right I do have. But at this stage, Lordship, if you look at the statute and the intention of the legislature, it's very clear which cases are to be omitted, which cases are to be considered. Very clearly, the objectives and reasons are have stated. No doubt, I have a LOI. I have a deed also, but I also have a protecting license. So two roads are open to me. I can always have the option. I have the privilege to at least depend upon one of the routes. So their letter says, their order says, in the light of above notification, that above notification is, Lordship, and it is regarding the 28 March notification of amendment. The previous paragraph mentioned about the notification dated third line, Government of India gazetted notification dated 28 March. So that notification, along with the communication or the letter issued by one officer of that agency. So a letter, whatever he writes there, that cannot supersede or override the provisions of the statute, as well as the statutory rules. He can write anything in his domain, but that is not applicable for public activities. But if Lordships direct them to produce this letter, that will
Not
give a
only
clear.
they- Not only you have not produced, they have not produced, I am here to interpret. But the fact remains.
So if Lordship gives us some time, we can procure
No,
it.
not
Lordship will,
necessary.
RTI will apply and we
not
do not want a order on the basis of some guesswork.
Not
No.
necessary.
Lordship, if
I
that is
don't
so
think
important, then we'll
necessary.
definitely, because
No,
one
I-
thing is that that
Mr.
letter cannot
Mr.
override
Saikia-
whatever is
Mr.
written.
Saikia, this court does not feel it necessary. The question which I am putting it as to whether the interpretations which have been given by this authority, the regional controller of
Yes.
mines, is in consonance with the first proviso to section 10(2)(a)
Yes,
is
I-
the question.
I'll
before
elaborate
us.
now, Lordship.
It is the question is before me is that
Yes,
Otherwise, there is
I
nothing
fully
else.
appreciate.
Now, he says that it has lapsed. Because here the word which has been used of the proviso is lapse. Now here he says that the mining plan goes because it has gone, whether he has the jurisdiction to say so, whether
is a
it is
different chapter.
contrary to the rules,
Yes.
it is for the Arunachal government to say. so,
Exactly, Lordship.
taking into account that nothing further remains and
Yes.
there is no execution of a lease deed, or if you are saying that there is no execution of the mining lease deed, so nothing remains, and they could have very well invoked the proviso, the first proviso to section 10(10) to A, but he has no business to
I
do so.
fully bow down to this. But Arunachal government is not doing anything.
Arunachal government, they are only doing something else. Let us now see what is the interpretation given by the courts as regards the proviso to section 10 to A. Let us see.
Now, going,
Because why the fundamental mistake which apparently appears to me about this is that there is a difference in the physiology used in the first proviso compared to that of the directions, because the direction says about the mining lease executed. Mining lease executed means there is a deed to be executed, which is not what has been stated in the proviso. So therefore, we are to look into it, is what does the courts have held as regards the proviso. Because with this paragraph gone, nothing remains in the case. Finished. Let us therefore see what does the courts hold
votes
as regards the proviso.
regarding the proviso.
How does the courts have interpreted?
Court, we have one judgment regarding the jurisdiction, but not on the
Jurisdiction is okay. We'll look at that. I don't know. But has the courts have interpreted the proviso to section
till
10?
date, Lordship. We could not find any judgment.
So it is for
But
me to
when
decide.
when the language is so clear, there may not be
So it
cases
is not
also.
necessary.
Language is so clear, there is no ambiguity, and if we read the proviso with the reasons and objects of the amendment, Lordship, because the now page 147, Lordship, let us come once more there. The statement of objects and reasons. Roman 6 down below. To close the pending cases of non-auction concession holders, which have not resulted in granting mining lease. So in our case is that there is a result of grant of mining lease. Despite passage of considerable time of more than 5 years, that 5 years is also there. That is the second condition. So ours, it was given on 29th of January 2021. Till date, we are within that 5 years period. That also there, if we look at from that perspective also, we are protected. The existence of these cases is anachronistic and antagonistic to the auction regime. The closure of the pending cases, pending case. The closure of the pending cases, ours is not a pending case, Lord. Would facilitate the government to put to auction a large number of mineral blocks in the interest of nation, resulting in early operationalization of such blocks and additional revenue to the state governments. And the next page, last, the bill seeks to achieve the above objectives. So with this objective, the amendment was done. Second proviso, Lordship will kindly see.
Yes.
The first proviso, provided that for the cases covered under this clause, including the pending cases. Our case I'm repeating once more, it is not a pending case. It has fructified to a grant of mining lease. the right to obtain a prospecting license followed by mining lease or a mining lease as the case may be shall lapse on the date of commencement of the MMDR Amendment Act 2021. Provided further that the holder of reconnaissance permit or prospecting license whose right lapse under the first proviso shall be reimbursed expenditure incurred towards reconnaissance and prospecting operation in such manner as may be prescribed by the central government. So I do not fall into that category also.
And if we apply six, Roman
Uh-huh.
6, which you have read in page 147, these would only come in respect to those cases where there have been non-auction concession holders which have not resulted in grant of mining lease despite passage of considerable time of
Yes.
5 years.
But we got it on time,
We got it in 2021.
21. We started the process about a year back because our prospecting license was over in May 2019 and we applied in August 2019. So it is very clear there in my humble submission, Lordship. There is no ambiguity here.
Okay, what are judgments we are having? We are only in issue with this. The second is the jurisdiction. The second is the jurisdiction.
Yes.
Who are they to say anything?
Absolutely.
Because there is no conflict with
I
any
have
law.
direct judgment on this by the Madhya Pradesh High Court Division Bench.
What does it say?
Last paragraph. তাৰপিছত কোনকেইটা পাবা? Lordship will kindly come to paragraph 2, last 3 lines. Ultimately, the respondent number 2, that is IBM again, the same authority, passed the impugned order revoking the approval of the aforesaid mining plan, questioning the same the instant petition was filed. Paragraph 7, heard the counsel. 8. The impugned order passed by the respondent number 2 as stated, therein is in exercise of the power contained under 5(2)(b) of the MMDR Act. In terms thereof, the mining plan was revoked by the impugned order. 5(2)(b) of the MMDR Act reads as follows. No mining lease shall be granted by the state government unless it is satisfied that there is a mining plan duly approved by the central government or by the state government in respect of such category of mines as may be specified by the central government or for the development of mineral deposits in the area concerned. So A, they have not stated here because A is very relevant here. I will place that also. Now coming to 9. On specifically being questioned, learned counsel for respondent number 1 and 2 fairly contends that the provisions of the said rules do not empower the respondent to issue the said order. That there is no power vested in section 5(2)(b) of the MMDR Act for issuance of the said order. Apparently, a wrong provision of law has been invoked. Therefore, the respondents have no power to issue the impugned order. Therefore, we do not find that the source of power as exercised by the respondent 1 and 2 has any nexus with the facts and circumstances of the case. And general clauses was also discussed. Now coming to that was also rejected. Paragraph 12. We are of the view that it is not a question that arises for consideration by this court. The question of interpretation of various provisions of law that are being argued by each of the counsels cannot form the subject matter of this petition. The impugned order only narrates the withdrawal of the mining plan in exercise of the power under 5(2)(b) of the MMDR Act. Since we have already come to the conclusion that the respondents have no power to issue the said impugned order under section 5(2)(b) of the MMDR Act, we are of the view that the said order becomes unsustainable in law. Even otherwise, we are unable to get any satisfactory answer from respondent number 1 and 2 to sustain the impugned order under section 5(2)(b) of the MMDR Act. Consequently, the petition is allowed. Now, let us see what is section 5. And Before going there, Lordship, the impugned order at page 207. Second paragraph.
So here he exercised the power under 5(2)(b).
Here also,
And then-
paragraph 2
Huh?
of the impugned order.
Yeah.
207, Lordship will kindly see. As per section 52B of MMDR Act, no mining lease shall be granted so and so. They have quoted that provision also. And as in the judgment, the same quotation is given.
Now, Mr. Advocate General, tell me one thing.
Lordship.
When is a mining lease issued?
Mining
This
lease was
lease,
issued.
there's a difference between the
Mi-
mining lease and the mining lease deed.
Yes, that is what I'm saying. That
Yeah.
there are three components: mining lease deed, and mining plan.
Mm.
It was issued on 29th of January 2021,
Mining
page 86.
means a lease granted for the purpose of undertaking mining operations and including a sublease granted for that purpose. This is as per 2(3)(c) defined. Now, prospecting license and how is the mining lease? And the mining.
Page 86.
The mining lease is being given up in terms with section rule 76 no? A.
76A. Communicate through an order its decision to grant the mining lease to any mining minerals other than those specified in first sheet.
So this is not actually a mining lease being given to you. What has been given is its decision to grant a mining lease.
Grant the mining. Grant.
No, no. It's a decision to grant a mining lease. There's a difference between both. A mining lease would be one which is to be executed so that you can go ahead.
Yes.
Whereas
Yes.
6A says communicate through an order its decision to grant.
Now, if Lordship is pleased to look at
Page
page 147,
And
The
kindly
object-
come to page 67. 63.
147 for a moment.
Of?
What of the statement of objection reasons?
Ah.
The same word, grant of mining lease. Grant of mining lease.
No, this may not come. Taking into account the 5 years have not elapsed. I'm not on that. But kindly see the language used in section 7(6)(a). Communicate through an order its decision to grant the mining lease. So it is not a mining lease. The mining lease has to be executed.
Now, Lordship will kindly come to sub rule 10.
Yes.
Upon issuance of an order,
It doesn't say a mining lease. It's upon issuance of an order
under clause A,
or 9 for
Order
grant
of
of a
what?
mining lease. For grant of a, so they will communicate an order that like which you do normally that the government of a governor is pleased to approve the allotment of a land to so and so.
Yes.
And thereupon the DC passes
yes,
an order.
now
of
Lordship will
allotment.
kindly come to page 86. What exactly is the language there?
Page
86.
The language is gone for a 6. What has happened out here is everything is gone toss. But
What they
you
have-
see, if not, if we, because if Mr. Seka, if we go by your submissions, that you don't want that lease deed to be taken into account, because the lease deed could not have been at all executed. There has been no compliance to
Let us-
710.
What was issued on 29 January? Let us see that.
Yes.
In exercise of power,
Yes.
here grant of, it is not decision to subject.
Hmm.
Grant of mining lease, not a decision to grant mining lease. In
So the
exercise of,
mining lease has to be executed.
it has to be executed.
So
We are not on-
therefore,
We are not on quarrel on that.
therefore, mining lease has not yet been, this is, if we go, because otherwise.
Mining lease will have to be executed, but there is a process. There are certain stages. Certain
No,
stages for that.
are we not, is this communication not a communication in terms with section rule 7(6)(a)?
Yes, it is as well as 5(2) of the act.
No, 5(2) can't come into, without there being a mining plan.
There is an amendment to that also. There are two situations. I'll make my submissions on that also. Let us see page 86, Lordship. Let us take this. Subject grant of mining lease of graphite for so and so area. In exercise of the power conferred by subsection 2 of section 5 of the Minerals and Mines and Minerals Act 1957, the government of Arunachal hereby grants the mining lease. It is not the decision to grant mining lease. It's
No,
about-
then it is completely contrary to section rule 710.
no.
Yes,
The
rule
order.
710 says, 7(6)(a) says categorically that it is an order or a decision to
Lordship, this is
convey.
a full-fledged order. Let me
I have read this. I've read your order.
read, and there are
Page
terms and
86
conditions also.
says that we are granting you the mining lease. But whether this is in consonance with section 7, rule 7.
Yes, Lordship.
If
Seven,
it is so, then you cannot say that we don't,
yes,
I
let us
know
read
the
section,
mining is the.
sub-rule 6. Let us read, Lordship.
Yes.
The state government shall,
Yeah.
on being satisfied that all the conditions specified in subclause 1 to subclause 4 of clause B of subsection 2 of 10A have been complied with within a period of 60 days from the date of receipt of the duly completed application, shall communicate it to an order its decision to grant mining lease for minerals other than those specified in first schedule of the act.
So it is an order.
It's now coming to 10. 7:10 says now, upon issuance of an order under clause A of subrule 6, or that is, we are concerned about 6, not 9, for grant of a mining lease, the applicants for such mining shall ABCD, these are the conditions.
Then there will be 11 which says about the mining lease.
Mining lease will come later.
So therefore you don't have a mining lease.
We don't have a mining lease. We don't have a, we are not disputing that. We don't have a deed because the deed can be executed after 10 ABCD are fulfilled. Let us see what is 10 ABCD. 10 says, upon issuance of the order. So order was issued, grant of lease, they have issued the grant of lease. After that, we have to do certain acts. Which acts are prescribed in 10 ABCD? May I read it, Lord? Upon issuance of an order under clause A of subrule 6 or subrule 9, subrule 9 is a different area. For grant of a mining lease, the applicant for such mining lease shall, number 1, obtain all consents approvals. So approvals will come for the mining plan. Permit, no objection as may be required under applicable laws for commencement of the mining operations. Provide a performance security to the state government. C, satisfy the conditions with respect to a mining plan as specified in clause B of subsection 2 of section 5. So mining plan also we have to comply with the conditions. Sign a mineral and production agreement with the state government. D, after all these things we do, 11 comes. The state government shall execute a mining lease deed with the applicant in the format specified in Schedule 7 within 90 days of fulfillment of the conditions specified in subrule 10. Then only once we fulfill all these 1, 2, 3, 4 conditions of subrule 10, then, and if no such deed is executed within the said period due to any default on the part of the applicant, the state government may revoke the order granting the lease. That is again 676. And in that event, fee paid under so and so shall be forfeited. So once we fulfill this, all these conditions A, B, C, D under subrule 10, then within 90 days, we have to execute the deed. We are at the stage of 10.
But you don't have a mining lease.
We have a grant.
No, you have an order.
We
You have an order, a decision to grant you.
That order has been specifically mentioned in the objects and reasons of grant.
No, there cannot be, because if it is an
There
order,
are two different stages. One is grant and one is deed. We have a mining grant. The grant has been given to us.
no, where is the grant? Say it.
Page 86. Page 86.
No. I will come to rule 7. Rule 7, does it say anything about the grant?
Yes.
Let us see where.
7.6 says grant.
Yes.
7.6a. After the state government on being satisfied of the conditions fulfilled above, communicate through an order its decision to grant.
Grant. So they have taken a decision to grant you a mining lease.
Yes. That is what is contemplated in Rule 10.
Yes.
Rule 10.
So it is an order.
It is an order.
To,
Order of what?
to
Order of
you a-
grant.
To grant you a mining lease.
To grant a mining lease. That is where
So therefore you don't have a mining lease. It is an order to grant you a mining lease. There's a difference out there.
order of grant. Order of
Therefore,
grant. The lease word will come after 11.
After complying with 10.
Yes, that is why the objects, the proviso relating to the objects is very clear.
Now therefore you come to-
Which are the pending cases?
No, the proviso would not come. I'm not saying on that thing because it has to say that those which are pending for 5 years and all. But let us see the proviso actually, which is appearing in section 10A to B.
10A.
To B. Provided that for cases covered under this clause, which is under 2B, including the pending cases, this right to obtain a prospecting license followed by a mining lease or a mining lease. This is a right. You have a right to obtain because of the order. Because of the order, you have a right to obtain the mining lease.
Agreed, Lord.
As the case may be, it shall lapse on the date of commencement of the mining year.
Lordship is reading which part? Lord?
The proviso,
Proviso.
the first proviso to.
Yes, 153. Provided for the cases covered under this clause, including pending cases, the right to obtain a prospecting license followed by a mining lease
Or a mining lease.
or a mining lease, as the case may be, shall lapse on the date of commencement of the Mines and Minerals Development Amendment Act 2021.
Now, if you have a right to get a mining lease, as of now, in view of the order, and you don't have a mining lease, then how do you take care of a situation?
Provide. This, there is a comma after pending cases.
Pending cases, including pending cases, comma, the right to obtain a prospecting license followed by a mining lease or a mining lease, as the case may be, shall lapse on the date of commencement.
Our case is Lordship.
Mr. Sekia, we will have the matter day after again.
Okay.
Have a look at it. How
Yes.
do you do? Jurisdiction I have looked into,
Yes.
but the fact of the jurisdiction, okay, but how do you take care of that? Because, and if you can find out that 13/4/2000, because what he is implying, if we see it is an order, then if it is an order for grant of, it's an only, if it is under 7(6)(a), if it is only an order to grant the mining lease, and if the mining lease will only fructify with the execution in terms with 711 upon compliance with 710, wouldn't it be a case where mining lease has not been granted as on the date of coming into effect of the 2021? This is the question. You think about it.
Yes.
Today,
Definitely.
hearing being inconclusive, list this matter again on Thursday, date to date.
Deeply applied.
But Mr. Advocate General, think about the other series
Yes.
matter, 24.
That will
You-
come on the upload.
Day after tomorrow, you think about it. What I intended to do in that matter is, say that let these matters be decided by authorities. Let them submit representation and let them to be decided, because there are things which this court would not like to enter now here. Because if I
There are
have to
different
enter
facts,
with,
factual situations.
there are a lot of
Lot.
factual situations out there. And then if it is left to the government has something, what do you call there's a word you use, free play in the joints. So with that being done, it can be very well done. So we'll have that 24 to that series again on Thursday.
All right, Mission item 18.
It will be coming top of the list. In fact. Okay. Right.
Yes, who is appearing? Okay. None has appeared on behalf of the petitioner on call. List this matter after 4 weeks. List this matter again on 16th of December.
19,
Oh, this matters. Very deep. And there is another matter. 19, along with that, another matter should be there. No.
item 19,
Mark the option and lines. Yeah, item number 25 to 24 to 64. List these matters again on Thursday. Huh? Thursday, taking into account that the learned advocate general appearing on behalf of the state has expressed some disappointment. Okay, we'll take it up again.
Lordship, when this matter was taken up
Hmm.
before in the single bench,
Hmm.
the case was decided on the ground that RTI information dated 10/9/2018 reveals that the writ petitioner had secured much more marks than the private respondent, that is the review petitioner now.
Hmm.
That was the sole ground for allowing the writ petition. Now, in order to come to that finding, certain materials were taken on record, which of which one is the RTI information 10/9/2018, according to which the petitioner has secured 298 marks instead of 214 as given earlier. There is a difference of almost 68 marks. Then, according to the RTI reply, there are some answer sheets, copy of answer sheets were annexed, which showed that the petitioner has secured 298 marks instead of 214 marks as stated earlier. Now, after the case was allowed, on the government also did not specify anything except to say that there may have been some irregularities. That was the only thing the government has said, no records were called for. Now, my lord, what happened is after that, after the impugn order was passed, we filed an appeal. Appeal was filed on 6/6/2022. During the pendency of the appeal, we also filed sought information regarding the computer test results, file notice, etc. Your lordship will see in page 66 of my review petition. Page 66. Sorry, before that, lordship, page 64 is the
You are
copy of,
the respondent number 6
yes,
in the writ.
yes.
You got how many marks?
I got 235 marks.
And
235
the writ petitioner got how much?
Petitioner got at that time 232. But later on, after this sort of information from the RTI and all, I'm talking now about just the written test. The petitioner had earlier got 214 marks.
We are concerned with the RTI information dated 8/3/2017, wherein it shows that the petitioner got 282 marks.
No, see, this is RTI dated 10/9/2018. There were three RTI information, sir. First, RTI information did not give. They did not give the. They did not give the answer sheets. What was
First
given
RTI
was
information was furnished on 7/2/2017,
Yes,
wherein it has been shown that the petitioner got 232.46 marks, whereas the respondent number 6 got 235.74.
yes, yes.
Whereas in
According to that lordship, sorry, am I audible, lordship?
yes,
According to that, what we are concerned here is the written marks. According to the earlier information, the written marks of the petitioner was 214, and including other Viva voice test and all, it was 232. 232. That was the information given in the statement of marks in the first RTI. In the third RTI,
in the second RTI,
sorry, lordship.
second
I had a
RTI, it has been mentioned that the petitioner got total
Yes,
200 and obtained total
298.
298 marks.
298 marks in the written exam.
No. In the written exam, the petitioner got 282 out of 300.
Yes, sorry. 282.
And further, another 16 marks out there in Viva voce out of 50.
Yes,
So total the petitioner got 298 out of 350.
yes,
Whereas you got 230, 28 point, 28, yes. You got 228.3. This is the second RTI.
yes.
Now what happened thereafter?
Thereafter, lordship, in order this after the second RTI, in the second RTI, they had also sought for the answer sheets itself, answer sheets of the petitioner, which showed that basing on which these marks were given according to them. Now, lordship, there is something very interesting here, lordship. We'll see. I have annexed that. In the reply of their petition, lordship may see in the reply objection. I'm sorry, lordship, I should have annexed everything, but I'm depending on their objection. Page 143. This is the part of the last RTI. RTI dated 10/10/2018. This is the answer script and answer script of the petitioner. Lordship will see a page
answer script on mathematics.
Yes, mathematics. Lordship will see page 144.
Yes.
Serial instructions, serial number 5.
There is only one answer to the question.
No, after that, 5.
Mark the question neatly by
Mark the option neatly by encircling it. In case of any confusion due to incorrect marking of option, no marks will be given. This was what was required to do, and it was done accordingly. Page 145 onwards is their answer script. Now the same thing, lordship, we'll see at page 148. This is for general English and general knowledge. Same instructions, lordship. Instructions are at page 149, same instructions. But here, lordship, will see none of the answers have been encircled.
What?
None of the answers have been encircled as per the instructions. This is of the petitioner. In the mathematics, he has followed instructions. In the general English and general knowledge, this is
put a tick mark, not encircled it.
Yes. Now, what happened is, now because they are saying the original is not there, original is lost, we don't know what might have happened, but your lordship will notice, because this was not encircled, in some of the answers, I will point out, lordship, more particularly, question number 5 in page 149. Lordship has found question number 5.
Yes.
There are 2 tick marks. So it is difficult to discern which one is that of the petitioner and which one is there of the examiner. Likewise, question number 6. Because these are not encircled, it is difficult to make out. Then question number 10. Then question number 11. Thereafter, Lordship, question number 29 in the next page. 29, question number 34, same page. Then question number 40, next page. Question number
But these
49.
documents were not there at that point of time.
No, it was there. It was there, Lordship.
Then why was this not pointed out?
Yes, it was not pointed out that I'm accepting. That was not pointed out.
Okay.
As per this, the petitioner actually did not deserve marks at all. Now, there is one point. Another thing is, Lordship, that after the this is pertinent also
And
because
how did you get this document?
no, this is part of the writ petition. Part of
Understood.
the writ petition.
How did you get this document?
Oh, they got a document to art. It is their document. It is not my document.
Close these documents.
Yeah. According to them, they got it through the RTI.
Get this document?
Lordship?
How did you get this document, Mr. Pangi?
RTI, my lord. My lord will see in every page it is marked.
RTI.
My lord, my lord is not audible.
You got these answer scripts from under RTI.
Yes.
Okay.
My lordship will see in every page there's a stamp of the APIO, my lord. Every page.
Okay.
Each and every page. It is authenticated.
Then next.
Then, Lordship, it may be said that because I have not pointed this out earlier, this may not be a ground for review that I'm aware of. Now, Lordship, but then, Lordship, after this RTI was, after this, we have filed this writ appeal. Then we sought for RTI regarding some other things, that is computer test results and all. Lordship may see page 64 of my review petition.
Yes.
This is a part of the additional affidavit that we had filed during the hearing of the writ appeal. This is, Lordship will see, this is an RTI application, and Lordship will see the details of information sought. This is in bold. Has your Lordship found page 160?
From the appellant RTI that the documents pertinent to the LDC were not found, which were reproduced demand.
Lordship, page 64. Page
Ah.
64. And I wanted to point out something here, Lordship.
Please.
Page 60, yes, page 64 of my review petition. This, Lordship will see the one involved, the details of information required.
Yes.
A copy of computer test / typewriting of 5 candidates of LDC. B, copy of result sheets of computer test. C, copy of relevant file noting for examination process. D, name and address of examination in charge / selection board who conducted the selection board. Now, Lordship will see, even at this point of time, I was not aware that answer sheets might have been lost or it may not have been there, because this is the information that I saw. Now, Lordship will see at page 65 is the asking me to pay for RTI fees. Then page 65 is the information. Page 66 is the information. This is to the ADC cum PIO. This is 7 July 2022. Furnishing of detailed information required regarding your letter dated this. Sir, with reference to the above, I am forwarding here with the detailed information as sought by the applicants regarding Moyong through RTI Act 2005 in connection with the recruitment exam 2016 as follows. Number 1, a copy of written test, a copy of computer test / typing test of 5 candidates of LDC were not found. Number 2, a copy of result sheet of computer test were not found. Was not found. However, physical marks were seen on the computer test papers. Number 3, copy of written answer scripts of mathematics, English, and GK of 4 candidates of LDC, except Miss Osikopa, were found in the office.
Who is OC Kopak?
is the writ petitioner.
Okay.
Hers was the only answer script which was not found in the locker. Then a copy of relevant file noting of
A copy of the written
yes,
four candidate and GK of candidates of LDC except OC were found in the office. So OC Kopak's answer script was not found.
yes. A lordship will see. Then copy of relevant file noting also not found. Then copy of name and address of examiners in charge of selection board constitution of selection board members were not found. Then lordship will see. While forwarding, I am to inform you that the board members were constituted to find out the above relevant documents relating to recruitment examination process 2016 by breaking the locker with the assistance of staffs ALCs, but the said documents were not found except were not found available except physical marks of computer test of 5 candidates and written answer script of 4 candidates. Answer script of Osikopak not found. Available copies of answer script and copy of board were enclosed in Xerox. So this is the next page is the board proceeding, which was conducted in order to furnish the RTI. This is the same thing which the board which was reflected here. The same thing of them. Now this is relevant. The non-encircling of Osikopak's answer script is relevant because the originals, it seems, are not there in the office. We don't know from whether it was available at that point of time. How was the process? We don't know. Lordship, I had pointed out at page number 64, what information I had sought is that even at that point of time, I had no inkling at all that this might have happened. What I had sought was other things like computer tests, typing result, etc. Because I heard from reliable sources that the Osikopak had not qualified in a typing test because typing test required 33 words per minute. That was what I had heard. That is why I had sought this information. I had not actually, even at that point of time, sought for answer scripts of Miss Osikopak because at that
Now, madam, you are saying
yeah,
that the answer scripts which were enclosed to the
Yes.
repetition and the basis on which it has been shown that he has got 282 out of 300,
yeah.
and more particularly, these are all fictitious documents.
Could be, Lordship, could be. What I'm saying is, Lordship, because in my affidavit also, before in the writ proceedings, in my affidavit also, what I have said is that except for Miss Osikopak, since there was no rechecking of answer scripts, all of us got what we exactly got earlier. There was an abnormal increase of 68 marks in case of the writ petitioner. So this is something which is not possible only through clerical mistake. There must be something deeper than this. So that is why this honorable court should call for an inquiry. That was what our stand before the writ petition. But since records were not called for, since originals were not there before this honorable court, it was difficult to ascertain this. That was our specific stand
So
because
your view ground, madam, is now that the basis on which this court formed an opinion,
yes,
the petitioner got more marks
yes,
than the respondent number 6,
yes,
is based upon certain documents which actually do not exist, which came to light upon the RTI which have been submitted on 5/7/2022.
yes.
Isn't
That
it?
is basically my argument also. The very foundation of the case in my humble submission
So
has
you
been
come
shaken.
in the ambit of clause B,
Yes,
section 114 of the code,
yes,
saying that when the petitioner could not produce a document with due diligence,
yes,
in spite of due diligence, a document was not available and could not be produced,
yes,
and has come to light now. So as such, it is a ground for review
yes,
and a requirement of the matter to be reheard, taking into account these aspects.
Yes,
isn't it?
yes. That is why I'm pointing out.
Okay,
page-
madam, I've got it, your point.
Yes,
Let us
I'm
now.
point, Lordship, I'm pointing out page 64 again and again because on the question of due diligence, Lordship, because even at that point of time, I was not aware that this could have happened. Yes.
Now, let's hear Mr. Pangi.
May it please, your lordship.
Yes.
And the whole case is sought to be turned on its head. The manner in which the repetition was filed and how under what circumstances lordship had passed the earlier order. Because the submission is being made that my marks were astronomically increased and all. In the review petition matter, even the repetition is not there, the affidavits are not there, nothing is there.
Mr. Pangi, don't,
Madam.
let us not go into those
Yes,
trivial.
yes.
Let us go into the question as to whether it is a case for review or not.
Yes,
Whether
I understand that.
the
Sir.
case, if it comes within, if this court had come to an opinion,
Yes,
this court had come to an opinion that you got 298 marks
Yes.
out of 350,
yes,
and she got 228 marks.
yes,
And as such, the question of you not being given an appointment to the post of the LDC was not proper. And as such, this court passed the
Yes.
judgment.
yes,
In that regard, you have enclosed certain answer scripts,
yes,
wherein these answer scripts, although those were not pointed out at that point of time, did not have the encircling out there, which you ought to have done. But it had the tick mark, and as such, later on, when an RTI is being made, they say that your answer scripts are not available with the authorities.
yes. And that's why, my lord, if you're
And as such, we did come within the ambit of clause B. That's it.
in my humble submission, no, my lord. Because at that point of time, these documents, my lord, were furnished to the RTI 2017. Apparently, it was available. Each and every document has been, each and every page your lordship will see is authenticated by the Assistant Public Information Officer. So at that point of 2017, admittedly, it was there because it says it's a certified true copy. If your lordship may kindly see the documents.
Now, what does the state say? State has filed the affidavit.
In the affidavit, yes, they did not say anything about it. Now they have not filed.
Because the state has to say this. What is
Yes.
this?
Yes,
Why
but
the state? Who is appearing for the state?
No, sir, I'm appearing for this state.
Yes, why? What is this? One fine morning you say, oh, this person has got so much of marks, and the other morning you say, oh, we don't have the records of it. On one hand, your PIO or whoever it is gives a certification of these particular documents, which were not. Now you say that no, these documents are not available. How did you get this certification? Where did you get these documents at all? Which you furnished to the petitioner. How did you get those documents if it is not available?
that is what I'm saying, my lord. So how can this be a case for review, my lord? This is at best a police case, my lord.
No,
Your
no.
lordship, please page 142.
Mr. Pani, it is a good case of review, taking into account that the government has taken everybody for a toss, including this court. Let us hear the government on what does the government say,
Yes.
why you are now saying that this particular person doesn't have you have to break the law. Meaning thereby those answer scripts were under lock and key. How did this disappear? Isn't it a very strange aspect?
Exactly, my lord. Because my case was, my lord, if I may just point out, initially, my lord, after the private respondent was appointed, I submitted an RTI application initially, seeking for the answer script of all the candidates. That was refused at page 135 of my objection, refused, saying that these are not available with us. Thereafter, I filed another RTI application seeking only my answer script. That was also refused. It is my categorical case that only after the transfer of the incumbent deputy commissioner, under whose aegis this selection process was conducted, after his transfer, I submitted another RTI application wherein only this was furnished. Even my answer script, my own answer script was also not furnished. That your lordship will find at page number 135,
Yes, government.
140.
We are not gonna. How did this happen? How did you furnish? the answer script to Mr. Panging's client when you don't have it, you had to break the law. How did you furnish? And now you are saying you don't have that answer script. Or did you furnish the original to Mr. Panging?
It's a certified copy, my lord will see from the document.
Therefore, I'm asking him, where is the original of OC OPAC?
Lordship, that part is there, that difficulty is there.
Not in the difficulty. You have come up with this, this board proceedings and all. This is now being given by the deputy commissioner. Earlier, who gave it?
This
Now
is
it
by
being given by the ADC for the deputy commissioner.
extra.
Because he categorically says that while forwarding, I am to inform you that the board members were constituted to find out the above relevant documents related to recruitment examination process 2016 by breaking the locker with the assistance of the staff ALC, but the said documents were not found available except physical marks of computer test paper of 5 candidates and written answer scripts of 4 candidates. Answer script of Miss So-and-so was not found. The available copies of here. Now, how is it not found?
Lordship, due to the change of incumbent, Lordship,
So the incumbent takes these answer scripts back home. Something like that. Was it something that happens in Arunachal? On one hand, you say that it is kept in a locker.
Lordship,
You file your affidavit stating why this thing has happened. You cannot say that you don't find. Then how did you get that? How did you get the answer script of OC Kopak, the petitioner,
no.
and provided to Mr. Panging's client?
My lord, in my
Here you say that you don't have it. Unless you have given the original to Mr. Panging's client.
my lord, my copies are not originals, these are certified copies, my lord.
Understood. That is why I'm saying.
Lordship, may I propose, Lordship, otherwise Lordship may direct the deputy commissioner to make the inquiry and report be produced before the National Court, and within a stipulated period, and basing on that, Lordship, this appropriate order can be passed by the National Court, Lordship.
No. There is the difference out there. That order I can pass only at the time of when I'm hearing the writ.
Yes.
I can't do that. But initially, for exercising the jurisdiction is based upon this document, which Madam has produced to that effect. That this is the document which says that OC OPAC's answer script is not there.
Original copy is not there, Lordship. Now, as of
You
now,
have the
Lordship.
photocopy.
The Xerox copy is there, Lordship.
Which one?
No, OC Kopak's, Lordship.
You are saying that the Xerox copy, but how on earth OC OPAC's the original copy is not there? Everybody's copy was there.
Lord, that part, Lordship. Then, Lordship, I may be given 1 month time, Lordship.
An affidavit stating how you don't have this thing compared to, and how did you provide Mr. Panging's client the certified copies of that very answer scripts?
Lordship, I'll do that, Lordship. And Lordship, kindly, that may be
If that is somehow explained properly, then obviously the question of review does not arise.
Lordship.
But if it is not explained, we have to review and then
Yes.
go for a CBI or whatever, maybe what is there.
Yes.
I don't go there much to Arunachal, anybody else.
My lord will see,
Lordship,
it's a very peculiar.
I may be given 1 month time, Lordship.
And one, it is the matter pending, you have not to file.
It has to be contained in my affidavit.
Your duty to file your affidavit. The state should have filed an affidavit. Earlier also, you did not file affidavit properly. We dispose it on the basis of a parawise comments.
Yes.
This is what has happened.
Yes.
And it is on the basis of the second RTI disposed it of.
Third RTF.
No, the second. Third
Third.
is recent one.
No, no, my lord, third RTI, as far as I'm concerned. On 2 occasions, I was not furnished with the SI scripts.
No, no, in my order, I have mentioned about 3 RTIs, 2 RTIs. The first RTI is where it has been said that you have got 228, she has got 235.
There was an RTI thereafter
It
also.
states that she has got 228, whereas you have got 298.
Yes.
Now, here is the case where all these new things are there is no documents to the effect.
But it's a peculiar case, my lord. As on, my lord, 10/9/2018, I was furnished with certified copies of documents, my lord.
Now, how is it possible?
After 5 years, my lord, they say this is lost. I don't know who did it.
Lahok. Heard Miss so-and-so, the learned counsel appearing on behalf of the review petitioner, who is the respondent number 6 in the petition. I've also heard Mr. D. Panging, the learned counsel appearing on behalf of the petitioner.
Yes,
And
respondent.
Mr. So-and-so, the learned counsel appearing on behalf of the government of Arunachal Pradesh. The instant review application has been filed on the ground that pursuant to the judgment passed by this court, dated 23/5/2022, in the BPC number 597/2018, the petitioner submitted an RTI application on 27/7/2022. In the said application, the petitioner sought for the copy of the computer test of typewriting of 5 candidates of LDC, a copy of the result sheet of computer test, a copy of the relevant file notings of examination process, as well as name and address of the examination in charge of the selection board who conducted the selection board. It is further relevant to take note of that on 7th of Madam, what is this type of the documents out there?
Lordship, page 66.
When did you apply?
Page 64, Lordship.
Page 64 is okay, but when did you apply?
Lordship, the date is not mentioned here. I think
On
somehow they
11th of
forgot.
July. 11th of July apply করেছে,
11th of July is the payment, which
and they reply on 7th of July.
no, the 7th of reply is an internal communication given to the PIO from the Deputy Commissioner.
So before you applied also, they have already processed. How is it possible? You file an RTI on 11th of July,
Yes.
isn't it?
No,
You
no,
pay-
Lordship, no. This 7th of July is a communication given by the Deputy Commissioner to the PIO.
Understood.
To the
So
PIO.
this
They have told
information was given prior to you asking the information.
No, Lordship, the information
When
will be
did you ask
given.
for the information?
No, Lordship, the date is not here.
What date is not there? You made the payment.
The documents do not show the date.
Yes.
But what I'm trying to say, Lordship, is that
No,
after this
You-
communication
all,
is
all hotspots everywhere. Your payment amount is on 11th of July.
yes,
Approx to the subject matter, I would like to inform you the information sought by you under RTI possesses pages as follows. So and so. This is by on 11th of July. When did you apply?
Lordship, this is not mentioned here. The date is not mentioned.
Okay. Date to mention no problem.
Okay.
Had sought for the following information he can delete. Pursuant thereto, on 7th of July 2022, the ADC, Siang District, Boleng, provided information to the petitioner to the effect that a copy of the computer test of the typewriting of 5 candidates of LDC were not found. It was further mentioned that a copy of the result sheet of the computer test was not found. However, physical marks were seen in the computer test paper. It was also mentioned in the information that a copy of the answer scripts of mathematics, English, and GK of 4 candidates of LDC were found, except that of one Miss Osi Kopak, who was the writ petitioner. Further to that, it was also mentioned that pursuant to the filing of the submission of the application, the board members were constituted to find out the relevant documents related to recruitment examination process 2016 by breaking the locker with the assistant of the staff /ALCs. But the said documents were not found available except physical marks of computer test papers of 5 candidates and written answer scripts of 4 candidates. The learned counsel, appearing on behalf of the review petitioner, submits that this court had passed the order, have passed the impugned judgment, have passed the judgment and order sought to be reviewed, basing upon the RTI information
Nine.
10/9/28. 10/9/2018, my lord. It is in my objection, page 142, my lord.
on basing upon the information provided on 10/10/2018
9.
by the EAC cum PIO of the DC's office, and who provided the answer sheets to the petitioners. The learned counsel submitted for the review petition, the learned counsel for the review petitioner submitted that if there were no answer scripts of the petition in the actual record, in the reports, as has been informed by the information dated 7/7/2022, the question of relying upon the information dated 10/10/2018 as well as the answer scripts of the petitioner and to be made the basis of the impugned judgment, of the judgment sought to be reviewed, could not have been made, and as such, an error apparent on the face of the record had crept in. She therefore submitted that this is a fit case for review of the judgment and order on both the grounds, that is, an error apparent on the face of the record as well as on information being available which the review petitioner could not procure at the time of the writ petition, when the writ petition was heard, in spite of due diligence. Per contra, Mr. D. Panging, the learned counsel appearing on behalf of the writ petitioner, submitted that the writ petitioner initially on 2 occasions were not provided with the answer scripts. It was only upon the change of the incumbent deputy commissioner that the petitioner was provided the information on 10/10/2018 by the EAC cum PIO of the DC's office, along with the answer scripts to the petitioner. He further submits that a perusal of the said answer scripts, which clearly show that the answer scripts were duly certified by the public information officer,
Assistant, my lord.
and as such, the question of non-availability of the answer scripts of the petitioner in the records as informed in the public information, as informed by the information dated 7/7/2022, is totally misconceived. This court, upon hearing both the counsels appearing on behalf of the writ petitioner as well as the review petitioner, inquired with the learned counsel appearing on behalf of the government of Arunachal Pradesh and sought for a clarification as regards the inconsistencies between the information provided to the petitioner on 10/10/2018 as well as the information provided to the review petitioner on 7/7/2022. This court further inquired with him, with the learned government advocate, as to how is it possible to provide the answer scripts to the writ petitioner on 10/10/2018 and that too duly certified, when the same was not at all available on record as informed by the information dated 7/7/2022. The learned government advocate sought for some time to explain the inconsistency and bring the same on record by filing an affidavit. Considering the above, this court fixes this matter again on 4th of December 2024.
No, sir, 18th of December, no, sir.
18th of December.
18th
Why
of
not on 25th? Yes. We give on 4th of December. Today is 4th. 4th of the, I'm giving you said 1 month, 1 month is 1 month. 4th of December 2024. And the Deputy Commissioner, Siang District, Boleng, is directed to file an affidavit bringing on record the inconsistency in the information provided on 10/10/2018 as well as 7/7/2022. The affidavit be filed by the Deputy Commissioner, Siang District, without fail on or before 2nd of December.
Obliged.
Admission item 20, fixed at 2 p.m.
Yes, Mr. B.P. Bora. What is this?
This is a petition challenging the 148 notice and a 147 order. The 146, it notice at page 19 is pertaining to a demand. Demand was made at page 17 of 2 crores 88 lakhs 40,390. Preceding that, there is a 147, 148 notice at
Where is the
page
148 notice?
19 and actual B.
Annexure? Then annexure?
Annexure B, page 19.
Whereas I have reasons to believe that your income chargeable to tax for the assessment year has escaped assessment within the meaning of section E. I therefore propose to assess so and so and hereby supplement. Then
Logic. Thereafter, at page 20, a assessment order have been passed.
Then
Is a detailed assessment order. I have challenged these two.
why should we interfere? File an appeal.
Logic, there is a provision for appeal at ground F. I have said that it is beyond limitation.
So what? If it is beyond limitation, you cannot file a writ petition for that. The law is very clear. There are many judgments. There's a division bench judgment of justice, of the chief justice also on that, following a Supreme Court judgment. Then
Logic, and natural justice also was violated. And when the-
natural justice is not violated. You were asked to furnish your return. 148. This was prior to this 2021. Huh?
But when it was filed, another point I had taken was regarding jurisdiction also. However, in the affidavit, a notification has been brought to record. In 3A, which precedes 148 and 149, that the limitation provided
Was extended.
was
So,
extended.
because last time I said I didn't dismiss it on that ground that you took the point of limitation. Then they come up with an affidavit to that effect. He brought it on record, that thing. I asked him to put it on record by way of an affidavit.
See, another thing recently, in case of
Rajiv Bansal is
also. In case of Rajiv Bansal's judgment, what is given that limitation period is available to department also. Paragraph 130. I have also brought the judgment. However, one thing I wanted to point out that the whole scheme of this assessment was that initially 143 notice was given. When I could not appear in the 143 proceedings, 144 was invoked. Now 144, Lordship knows, is a based judgment, based on judgment. Lordship, there in section 153 also, there is a limitation for assessment under 144, which therefore, Lordship sees.
Tell me.
Paragraph 114, conclusions.
After 1st of April, the Income Tax Act has to be read along with the substituted provisions. Law will continue to apply. Which paragraph you are referring to?
Paragraph 114, looks true.
Huh?
Paragraph 114.
Oh, you got only one copy of the judgment. This is the state of affairs of the income tax department.
It's available.
As the people stop paying income tax, then
It is
good news. State government position is better than the income tax department.
Suppose B, Tola will continue to apply the income tax.
What is this Tola?
Tola looks like that. It's a short form of the amendment. Tax, something. It's a short form of the amendment that was brought in. That is during public lordship for all the tax pay. Limitation was extended.
Oh, that one. It
Please,
is Tola business.
note that it is not limitation, extension of limitation is not available to the state.
A taxation and other relaxation, okay. COLA will continue to apply to the Income Tax Act even after remand and if any action or proceeding specified under the substituted falls for completion between remand to remand. See, now override section 159 to the extent of election for issuance of reassessment notice. Will extend the time limit for the grant of sanctions specified in the case of section 151 to state the time. The assessment year. Then the specified will be under and the time. When was this done?
Was done, the assessment year 2013 or 14 and 14. Based on the time.
No. This
Financial year
notice was issued when?
2021.
31/3/2000. So it was within time.
It is extended.
Extended till 31st of March 2021. So it is there. Limitation is gone. Then
Lordship, prior to the assessment order, the 140, Lordship would see section 153.
Mr. Counsel, I'm not going to look into all this. First and foremost, there is an assessment order. Once an assessment order, you are required to file an appeal. You want to challenge on what basis on the 148? On the ground that he did not have the reasons to believe. That must be the only ground, nothing more than that.
Lordship,
A jurisdiction is conferred upon an income tax officer under 147, provided he has reasons to believe that the income have escaped assessment.
Yes.
That's it.
yes,
Now, the reasons to believe has to be already decided in many judgments. More particularly that refrigerator one, what is that? Kelvinator. Kelvinator refrigerator is the case.
Lordship, what I was submitting is that the reasons to believe that the SSC has escaped assessment. Whether he has escaped assessment or not, for that, Lordship, section 144 is invoked. Now, 144 has also a limitation under section 153. Now, so the initial assessment of 144 is also beyond limitation. That is also not covered by the judgment of Rajiv Bansal, 153. Lordship, may I read?
What? You were given so much of opportunity.
What has happened, my certain accountant also died of COVID, Lordship. I was severely COVID affected, Lordship. Several days I was in hospital. I was also in oxygenated for several months. Therefore, Lordship, I could not.
Therefore, you could not
Answer to all the queries.
Fantastic. Go there.
Lordship,
File your appeal.
Lordship,
All these cases, all these aspects,
yes, Lordship, initially I filed because of since the affidavit is filed and the judgment is there, my ground of jurisdiction goes. Now I have to file an appeal, but just why I wanted to show 153 for once.
Yes.
Section 153.
Tell me. Hey, income tax section is 150. Yes. Yes.
Time limit for completion of assessment, reassessment, and recomputation. No order shall be made under section 143 or section 144 at the time
after the expiry of 21 months from the end of the assessment year in which the income was first assessable.
Then? Well, are you challenging the initial best judgment also?
Initial that because it is done one.
Are you challenging the initial best judgment? I'm asking you.
That judgment, because
You are challenging the initial best judgment assessment.
no, I have challenged the 147.
So what is wrong with the 147? 147 power is what?
147 is based on 144.
Yeah.
The
but,
judgment
no,
itself is-
understood, but what is the, how much is the limitation for a year? It is 8 years or something. Where is the period? Period is given under 148 A. Oh no, power of reopening income assessing is 149. 149. Yeah, time limit. No notice on the year shall be issued if 3 years have elapsed from the end of the relevant assessment, unless the case falls. If 3 years but not more than 10 years have elapsed, these are amendments.
The
Relevant assessment
earlier
year,
provision,
unless the assessing officer has it in possession of so and so, so and so. No notice under section 1 year should be issued in any of the month. If any of the month. Earlier it was 8 years or something.
6 years.
3 years and
6.
so your period completes when? This is for the assessment year 13-14 is financial year 2014-15.
19.
Uh-huh.
But we take advantage of that Tola law.
And Tola, you get it till 31st of December. March.
That has been approved by the Honorable Supreme Court also. No, Lordship, the 147 order is based on the 144 assessment. Now the assessment itself is time barred.
Which one?
The 144 assessment.
Very good. They should have therefore do it. So are you saying that reassessment cannot be done because of the fact that the assessment was incorrect?
Assessment was time barred.
So you didn't challenge that. Therefore, I'm asking you, are you challenging the best judgment assessment now after the reassessment proceedings have been done?
But I have challenged, Lordship, the 147 assessment order.
Understood. You have challenged the 147, 40. See, this, it is something like this. They 147, they initiate reassessment. They don't reassess.
Yes.
You have to understand. Assessment initially is being done. There are various forms of assessment. First will be the assessment, self-assessment.
139.
One will be an audit assessment. One will be an assessment by self, there will be a scrutiny assessment. One will also be an assessment which has been done by what you call the best judgment. Best judgment is an assessment when you don't do it within a time or he can do it by himself. So now, thereupon, if an income is escaped, then they initiate proceedings under 147. 147, and for doing so, when they initiate the proceedings, the jurisdiction is given under 147. Once 147 is done, 148 comes in the picture that you have to be issued a notice.
Before 147 order.
You are only given a notice. Now, if you see the Supreme Court judgment in GK Drive Shares, it says, once you are given a notice, it is your duty to furnish your return. First, you furnish your return. Forget about other things. Thereupon, you may challenge many others. Because in the notice under 148, you are informed categorically that, you see, we are going to kindly submit your return. That is what has been mentioned. So they do this 148 then. Then once you do it, then you again go back to 143. It's something like a review. You review it. Review, then you fix it for hearing of the repetition. Something like this. Everybody follows a similar principle. What else?
what I was on is not you would see the kindly see the order under 147, just two lines. So page 25, scope of 144, it is given. What you would see. I could not respond to 142 notice. Thereafter, but I filed my return. Initial return I filed.
So why didn't you file an appeal? You file an appeal along with you, it can be condoned. It is already given. Well, no case.
Now after this SOLA amendment, now I had a case of 144, but I can file an appeal for this.
So we will give you the period during which the repetition has been here be taken into consideration as prosecuting bona fidely before us. So, nothing. Heard Mr. B.P. Bora, the learned counsel appearing on behalf of the petitioner. And Mr. S. C. Kyle, the learned counsel appearing on behalf of the Income Tax Department. The petitioner in the instant proceeding have assailed the impugned notice. What is this notice? What have you written this? What is this? 21.3?
21.3 is the one.
Have assailed. You are not
147
challenging 148 also.
I'm challenging
Where
147
is your
order.
148 challenge?
Which 20 is the 20?
Where are you challenging the notice also? Goodness.
I am challenging
Where?
the 21/3/2021.
Is an order.
Order under 147.
You are not even challenging the initiation. The petitioner in the instant proceeding have assailed the order dated assessment order dated 21/3/2022 passed by the respondent number 3. Respondent number 3 for the assessment year 2013-14, whereby the income was assessed at rupees 4,32,03,305. And the petitioner was held to be liable to pay an amount of rupees 2 crores 88 lakhs 40,000 The petitioner in the instant proceedings have exercised the jurisdiction under Article 2 to 6 of the Constitution, primarily challenging the initiation of proceedings under Section 148 and 147 of the Income Tax Act of 1961. On the ground that the same is beyond the limitation provided under Section 149 of the said Act of 1961. It is, however, pertinent to mention that the said jurisdictional issue which have been raised no longer exists, taking into account the provisions of the Taxation and Other Laws (relaxation and amendment of certain provisions) Act 2020, which enlarges the period of limitation to 31st of March 2021. Further to that, it is also seen that in a recent judgment of the Supreme Court in the case of Union of India and Others versus Rajiv Bansal, reported in Hetu Sailobodi, SSC Online. You have the SSC Online?
2000. Yeah. No, I went to the Supreme Court.
Thank goodness. Reported in (2024) SCC Online SC 2693. The Supreme Court had held that Section 3(1) of the said Act of 2020 overrides Section 149 of the Income Tax Act of 1961 only to the extent of relaxing the time limit for issuance of a reassessment notice under Section 148. And further held that if the time limit of 4 years from the end of the assessment year fell between 2020 and 31/3/2021, then the specified authority under Section 151(2) would be extended up till 31/3/2021. In the instant case, it is seen that the notice under section 148 was issued on 31/3/2021. And as such, the same was within the period of limitation. Further to that, it is also seen that pursuant to the assessment pursuant thereto, the assessment order was passed on 21/3/2022. And the petitioner, therefore, being aggrieved, ought to have taken recourse to the statutory appellate jurisdiction rather than approaching this court under Article 2 to 6 of the Constitution. Taking into account that the jurisdictional issue which was raised is no longer there, this court does not find any good ground for entertaining the instant writ petition. Accordingly, the instant writ petition stands dismissed on the ground of being not entertained. It is, however, relevant to take observe that the dismissal of the petition on being not entertained shall not act as a bar upon the petitioner to prefer any appeal under the provisions of the Income Tax Act of 1961. Further to that, this court also observes that the period from 26/9/2022 till date be excluded while computing the period of limitation in preferring the appeal.
May I read it, my lord? Trying to point out from page 62 is, my lord, it was on the insistence of the Council for the Coal India, my lord, that they considered that the Union of India having given certain directions to them, my lord, and they initiated certain proceedings against them, out of which, my lord, this impugn debit notes have arisen, my lord, and therefore Union of India was a necessary party. And hence, this honorable court had directed us to impede the Union of India, which was done, my lord, at a later stage. And having done that, my lord, at page page 75, my lord. Page 75 of the affidavit. It is part of the records. I just annexed here with for convenience.
Page 75.
Yes.
Yes.
From the second subpara I did, my lord, it is submitted by so-and-so that the matter in issue in this writ petition is pending before the larger bench of the Honorable Apex Court, and the same is yet to be heard and disposed of. There is no dispute with the fact of pendency of the matter in the issue involved in these writ petitions before the Honorable Apex Court. Considering the same, let all these writ petitions be admitted, issue rule, accordingly no further notice. My lord, then the last second para is important, my lord. In the meantime, the Union of India is directed to file their affidavit in order to bring the actual purpose behind the said move of the concerned department and whether the duties so imposed can be given effect retrospectively, and thereafter it was directed to be listed. I have also annexed copies of the Supreme Court orders, my lord, passed in a bunch of cases. There are many cases, my lord. I got hold of one or two, and the last order, my lord, in the year 2024, my lord, the matters were listed at page 80.
Then
The appeals pending before the Honorable Supreme Court, they were admitted, my lord, and the appeals have been directed to be before the 3 judges bench, my lord, to be listed in normal course. This is order dated 20th September 2024. And hence, we understand that the matters before the Honorable Supreme Court is pending. My lord, these matters have been pending here for the precise reason, my lord. There are same issues, my lord. Ultimately, whatever the Honorable Supreme Court will hold, will govern all the petitions pending before the various high courts in India. Now, so far as the Coal India Limited is concerned, my lord, they filed transfer petitions because lot of matters were pending before various high courts, my lord, that it should be decided in one court, so there is a parity in whatever direction that may come. So far as this bunch of matters, since it was pending that, okay, whatever is decided here, it will be decided here. That is how it was kept pending. Now, in the last proceedings, I understand, my lord, I was not present, that this honorable court took into consideration the order dated 4th May 2016 and has posted it, the matter today. The subsequent orders that were passed that the Union of India being a necessary party, which was a contention raised by the Coal India Limited, that was perhaps not pointed out by the Council of the Coal India. And the fact remains that although there was a specific move done to prepare applications, to file applications were allowed, there were implemented notices were served, directions were given to the Union of India to file their affidavit, they have not come forth. So far as the dispute is concerned, we do not have any dispute, my lord. It is only because Union of India initiated certain proceedings under the against the Coal India Limited, alleging evasion of certain taxes payable by Coal India and the subsidiary companies.
why the matter has gone to the Supreme Court?
Why? My lord, they filed transfer petitions, my lord. There were a lot of cases all over India. So Coal India perhaps for facilitation.
Those transfer petitions were dismissed.
No, my lord, that is not a correct statement, my lord. Exactly, that is what I'm trying to point out.
No, there is an order passed by the Supreme Court.
That observation was recorded on the basis of statement made by the Council for the Coal India Limited. And therefore, I verified, my lord, that there is no order dated 12/5/2018. The Honorable Court also recorded that we did not bring it to the notice of the court. I requested this Honorable Court to take item number 10 first, because Pankaj Coal Enterprise name was specifically mentioned by the other side, that we approached the Supreme Court and Supreme Court has rejected, which is, my lord, in my respectful submission. I verified all the records. The petitioner has come by way of an affidavit that we never approached the Supreme Court and no such application was filed, and there was no question of rejection, and there was therefore no situation arising that I should have come and informed this Honorable Court. I would have done that, of course, if we would have approached. So that was an
I saw an order passed
Yes,
by
I have annexed it in the affidavit, madam, for the convenience of this Honorable Court at page 62.
page.
62.
But necessary steps for improvement was not taken in the meanwhile. Yes, but those petitions were rejected on demand by the Supreme Court, and the High Court is requested to expedite the disposal of the pending litigation, preferably within a period of 4 months.
This was recorded on the basis of statement coming from the Coal India Limited, including the statement that we did not file any application for improvement of Union of India. Because we did not have a direct grievance against Union of India, that was why we had not implemented, but they insisted that they are a very necessary party, and it is because of a direction passed
Write the order of 12/5.
12/5/2015. There is no order, my lord. That is what exactly I'm trying to point out.
There is no order of the
There
Supreme
is no
Court.
order, my lord.
Why will this court reject?
Because my lord, when a senior counsel makes a statement, my lord, it is normally done with responsibility and therefore, therefore the court took it
Yes,
to be a correct
Mr.
statement.
Ahmed, you were appearing in that matter. There was no order of 12-5.
We never made the statement.
Huh?
Made the statement that.
Then who made this statement?
It's not by. This was not the.
There is no order of Supreme Court.
It's still pending.
Now, you file transfer applications. No, but why the matter is there in the Supreme Court? Because the Supreme Court are not transfer applications. These are all civil appeals.
Those are other cases from various parts of India.
These must have been orders being passed by the various, various high courts, which had led the matter go to the Supreme Court. Has the Supreme Court in any matter, why these matters have not been done transferred to the Supreme Court?
My lord, because they filed individual applications, my lord. They did not file a general application seeking transfer. We thought even our matters will be transferred. But we thought even our matters will be transferred, but they did not file a general application seeking transfer of all petitions before various high courts. And at page 75, my lord, when this honorable court takes up this matter, they admit the fact that the pendency of the issues involved in the writ petition before the honorable apex court, which is recorded, and I placed it before this honorable court.
So you are concerned with the imposition of central excise duty.
And not really, my lord. What I am trying to say that when the sale was made, they raised the bill, including all taxes, duties, everything was done. We paid everything. We have nothing in due. But they evaded paying tax to the central government, and central government has initiated a proceeding against them. And to save themselves, they have raised these debit notes, my lord, retrospectively. In fact, the central
So
government,
you mean to say you paid the royalty and the stowing charges?
everything at the time of billing, I paid the 100% value, including all these charges I have
Let
paid.
us see your bill.
On retrospective, my lord, I do not have those bills, neither they produced, my lord.
No, then what, how is the restitution filed?
My lord, this petition is filed challenging that you henceforth you want to charge anything you charge. Retrospectively, if you want to charge, you give on what basis you are charging, my lord.
No. Now tell me, why are you challenging these actions?
Have raised a fresh debit note, my lord, which is at page for item number 10, my lord, the debit note, my lord, at page 29. They do not give any details, my lord, of this. Page 29, rather at page 30, my lord, relating to which notice which sale, they do not give any detail.
Debit note on account of area of Central Reserve corresponding to VAT CST from so and so to so and so.
To so and so, there have been thousands of sale notices against which,
No, show me that you have already paid.
my lord, first I will have to understand for which they are charging me. Only then I can show which I have paid. Since
So
2011
you want
to
this court
2000
to give you a clarification.
my lord,
Then-
it is for the other side to come for the clarification, my lord.
Why?
They have, my lord, I am saying this is dated 24th April 2013. Now they are raising a debit. They are raising, my lord, I'm not in a civil suit. I understand this, my lord. I'm invoking the extraordinary jurisdiction of this honorable court, so I understand my limitations, my lord. My lord, this impugned debit notice dated 24th of April. Now, in this 24th April, they say that on account of arrear from 1st March 2011 to 28th February 2013. And they enclose this debit note, which is in the subsequent page 30.
Then
And if on the face of it,
excise duty on the coal of removal, this
Yes.
amount.
Yes, this
Education
amount,
sales, this
with
amount.
respect- with-
Sales, this amount.
with respect to which,
Central sales tax on so and so, this
This
amount.
amount.
State sales tax.
exactly, this is what they say only. Now, this is in with respect to which sale, for what quantity of coal, nothing has been assessed or excise duty on coal removal. Coal of how much quantity, my lord?
Is it your case that they have one fine morning woken up and have you asked you to pay this amount of money without providing you details?
And also, my lord, for a period for which I have paid them all charges, taxes, duties, royalty, everything I have paid them.
And what is their reply?
They reply, they say that arbitration clause go to arbitration. For me, a sale that is completed, why will I go to the, it is
Yes, Mr. M.J. Raman. How is it possible? One fine morning you say that this amount is to be paid. How? You have to give the details. Otherwise, it would be an unreasonable year. Provide them the details, matter ends there. You are concerned with details,
yes,
where you have not paid.
whatever,
Whether you have paid these duties or not, you show it to them. They will look into it and then come up. Matter over. Why should I look into all these things?
let them,
This is not any issue of any substantial importance.
exactly, my lord. Let them give the bills raised that time. What I paid, what is pending, let them give, my lord. If there is anything I need to pay, I will pay. You cannot just give a general yeah and to save your skin from the
In all cases, same.
same.
And let's go. We set aside this. We set aside this communication, giving them the liberty to provide you details, and thereupon you reply, and then whatever you do, matter over. Isn't it, Mr. Member?
My lord.
You cannot come up one fine morning and say that you have to pay this amount, this is the amount. You have to give details where you have not paid, where you have paid or what not. Give them a proper notice. You want to realize something, you have to give them that this is the amount why we are entitled to. You cannot come up with a notice out there that kindly pay us in this manner.
Let us come in 2 days.
This is a simple issue.
Yes, this will-
What is your reply? Let us see.
Yes, we will keep you between the affidavit, pricing, licenses. Now let's make.
So the case happened in view of this. There was the question arose, the question which is before the court is this. Royalty and stowing charges were brought within the ambit of the sale price. And when it is brought within the ambit of the sale price, the Central Excise Authority says that you are to pay the central excise on that amount. What they did, they paid the royalty and the stowing charges, but in that, it was not brought within the ambit of the purchase price. And as such, they only paid the amount, that is the purchase price, the auction price, and did not include the central excise, and on the auction price, they paid the central excise duty. If we come to clause 4.4, the buyer while bidding shall quote the bid price per ton in Indian rupees as base coal price for FOR and FOB, so and so, exclusive of other charges like statutory levies, surface transportation charges, sizing beneficial charges, taxes, cess, and other. These charges and paid shall be paid be on the buyer's account. So the buyer will be paying that. They paid. But the fact remained that whether the central excise duty was to be payable on the bid price plus these charges together or only on the bid price. That was the issue. Now the Central Excise Authorities has come to you and hold you, no. You are now liable to be payable so and so. Now, have you challenged the decision of the Central Excise Authorities anywhere, or you just tried to impose it upon the petitioners?
But already, as the funding has gone to Supreme Court, and it's pending there for. It's the same. The earlier code was not included here.
No, because you came, coal was brought within the ambit of the Central Excise Duty only from 1/4/2011. Prior to that, it was not. So there was an increase or decrease in material. The question is, what should we have been? The Central Excise Duty should be payable on what amount? Whether it was purely the bid price, or was it inclusive bid price, inclusive of the stowing charges as well as the royalty. Now, in view of the recent judgment of the Supreme Court, the 7 judges, whereby Kesoram has been, India Seawind has been overruled, what is the implication of the 9 judges bench?
First of all, you know, the transaction value is shown in here. Transaction value.
Where is that? Huh?
There is in the Central Excise Act.
Yes.
Section 4.
Central Excise, 1940. Central Excise. I could see some orders being passed by some courts where, oh yeah. The only stage. Where is a judgment passed by any court by which the matter is before the Supreme Court? Transaction value means the price actually paid or payable for the goods when sold includes, in addition to the amount charged as price, any amount that the buyer is liable to pay to or on behalf of the SSC by reason of in connection with the sale when he is payable at the time of demand. So your question now therefore is, so it is inclusive of that which you did not take initially. Now you want to recover from them.
We paid it to the government. We have paid it to the government.
Very well, you paid it. Now you want to recover from them.
Yes, yes, yes.
So are they challenging that it cannot be brought within the ambit of the transaction value?
Because they have not,
They have not challenged that.
they have not-
So how the matter is of importance? You say this
because
is
it
it.
a debit note. On the basis of the payments they made, we raised the debit note. And they challenging the debit note.
Then why you are not going for an arbitration instead of doing directly asking them to pay? If they don't pay, go for arbitration.
We can do that, I think in the matter of pending.
No, because it is a contractual dispute between you and them.
Contractual.
So go for arbitration. It cannot be a case because here, whether it is inclusive or not, yes, it is. Because they are not challenging that.
They're not challenging it.
They are not challenging as to whether it is inclusive or not. That aspect is not being challenged here. What is they challenging? That you cannot do it in this manner. Now you want to make some recovery. Whatever maybe you want, it is not a question of retrospective recovery.
Future they pay.
Huh?
Subsequently they pay.
No, they are paying, it's okay. But you are entitled to this amount. It's a dispute between both of you. Why you're not going for arbitration rather than if they are not paying, you cannot impose upon them or deduct it from some other security or any bidding. Because your policy categorically shows that against each auction, there will be a separate, once it is being registered, they will deposit certain amounts which will be there. Full amount which will be there. So you cannot touch those amounts in the name of the debit notes.
You know that.
So if you want to recover, you have to recover before them. How can you do so from them in this manner? By writing a letter to them, yes, you writing a letter, then you recover, go for a recovery process as per law. But the question is, they are not challenging that it cannot be brought here. They are challenging that how can we do so? It's not a question of retrospective. It is a question of wrong realization or inadequate realization.
They pay now that they paid over, they have not. If that had been, it was not.
It has been given a flavor of a retrospective realization. It's no. The realization as from 1/4/2011, if it is there as per law, it is the realization has been done correctly. But if you want to realize, you have to do so as per law, not by writing a debit note. If you are writing on it, then you take due process and as per law. What do you say?
Yes, my lord, I'm grateful to what.
But
has
your
happened.
case, you don't fall out there. Whether it is a transaction, is it your case?
I'm not my case. That is not my case.
So under your case is here that you are asking me to pay certain amount. I have paid. But their case is no. It is not the question that you are to pay. You have done these transactions with me. And in these transactions, you have paid the central excise only on the bid price. But you have not paid the central excise inclusive of the royalty and so, which was required. And as such, the differential amount they had to pay. Now they want to recover it from you. Therefore, they are issuing a debit note. Very well. Now, if they are to issue a debit note, they can issue a debit note, but they cannot realize from any other thing except by due as professional of law. You have to file suits or the arbitration. Do ahead. But this is not a matter which is there before the Supreme Court. 100% I'm saying this cannot be the matter before the Supreme Court. Otherwise, this matter wouldn't get so much of delay. For lesser the human being like me, it doesn't take so much time. Think that.
I don't know why.
My lord, that, yeah, that, if the Coal India Council does not know, who will know? They are party there, I'm not a party there. My lord, at page 41.
Your simple, madam, your simple case is you want to make some unreasonable recovery. If you want to recover, you have to recover as per law by proving that this is the amount I'm liable. Because you're not challenging. whether it falls under 4.3 or not. So under such circumstances, this is your simple case. Why should we delay the disposal of these matters?
My lords, if I may just bring to my lords notice, my lord, the 5th March 2013 direction, which was the basis for them to come up with this debit notes, at page 41, my lord, just the relevant portion, my lord. At page 43, my lord. The page 43, my lord, it was further undertaken, my lord has got it. It was further undertaken that the differential central excise duty, by considering the elements of royalty and stowing excise duty for the purpose of arriving at the assessable value, would be paid by coal producing subsidiaries of Coal India Limited for period March 11 to February 2013 within so and so. Now, in view of the above, now whatever has happened, it was considered, my lord. Now, in view of the above, the coal producing subsidiaries are hereby advised to discharge the past central excise duty liability for the period covering March 11 to February 13 immediately. This payment to the exchequer, I skip this, my lord. Then the next one, B is important. To consider royalty and stowing excise duty for the purpose of arriving at the assessable value for levy of central excise duty in all coal sale bills on and from 1st March 2013. And from 1st March 2013, the petitioners, whoever have been participating, my lord, they have been paying from 1st March 2013 itself, that going by this.
Madam, it is not a question of retrospective
I
realization.
have understood, my lord.
It is a case where they have, now they are trying to recover it from you.
Yes, I get
If
it,
they
my
want to recover, they is anything, they have to go for arbitration because they have raised the point that it is a case of arbitration.
arbitration. Correct, my
Go
lord.
then.
I'm grateful.
It's a simple, or file suit, barred by limitation. They have been successful. You are only raising a debit note, but you cannot touch other contracts.
Period of that.
Then what remains in this case?
Arbitration is okay. We can approve arbitration.
You recover as per law. You want to recover, it has to be as per law. You cannot recover by, you may issue a debit note, but you have to prove how it is. They are saying that on what basis you are doing. On fine morning, you say that you pay us this amount. You have been imposed or directed to pay central excise duty. And one fine morning, you say that the state tax also you pay in this. Why? Where is the question of the state tax coming? See the debit note, you mentioned about a huge amount in state tax, isn't it? And you see, state sales tax on sold coal, 21,000. Central excise is 44,33,000. So this is, you have short levied from them or short collected from them. You want to do it, you have to do it as per the provisions of this. You want to recover. How will you recover if it is not paid? Arbitration at Calcutta, the place to be notified by CI. Oh, take them to Calcutta also. Madam will just arrive from Delhi, then you will take her to Calcutta. Chalo, we dispose of these. Ms. B.S. Goyal, the learned counsel appearing on behalf of the petitioners in the batch of writ petitions. I've also heard Mr. M.J. Damik, the learned senior counsel, assisted by so-and-so, appearing on behalf of the Coal India Limited, as well as Mr. C.K.S. Burua, appearing on behalf of the Union. The present batch of writ petitions have been filed assailing the actions on the part of the respondent Coal India Limited in issuance of, in every case, debit notes have been issued, no? In issuance of debit notes and thereby demanding the petitioners to pay amounts on account of arrears of central excise duty and corresponding VAT/CST from 1/3/2011 to 28/2/2013 against the coal supplies made by Coal India Limited to the petitioners during that said period. The case of the petitioners herein is the petitioner, in terms with the spot e-auction scheme number 2007, had purchased coal by making due payment of the bid price, statutory levies, surface transportation charges, sizing/beneficent charges, taxes, cess, royalty, etc. at the time of delivery of the coal. During the period from 1/3/2011 to 28/2/2013. However, sometime in the month of April 2013 onwards, the petitioners herein have been issued various notices, various notices, asking the petitioners to make payment on account of the arrear of central excise duty and corresponding VAT/CST for the period from 1/3/2011 to 28/2/2013. The learned counsel appearing on behalf of the petitioner, Ms. B.S. Goyal, submitted that the said imposition so sought to be made without any basis and details and has been arbitrarily imposed upon the petitioners. She further submits that the perusal of the debit notes as well as the enclosure thereto could not show any details as to how the said amount have been calculated and in respect to which sales, which period of sales these amounts were payable. The learned counsel submitted that the manner in which the recovery is sought to be made is completely arbitrary and illegal and is foreign to the settled principles of law. On the other hand, Mr. M.J. Ahmed, the learned senior counsel appearing on behalf of the Coal India Limited, submitted that the Coal India Limited came within the purview of the Central Excise Act 1944 with effect from 1/4/2011. Earlier to that, there was no central excise duty on coal. He further submitted that at the time of submission of at the time of filing of the returns under the Central Excise Act, the Central Excise Department did not agree to the interpretation of Coal India Limited that the royalty and stowing excise duty would not come within the purview of the transaction value. And as such, imposed upon the Coal India Limited the additional amount in view of the increase in the transaction value on account of the inclusion of the stowing excise duty as well as the royalty. This increase in the excise, central excise duty, which the Coal India Limited had to pay, is sought to be recovered by way of issuance of these debit notes. First of April, 1st of March 2011. This court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration. The petitioners in the instant proceeding have assailed the actions of the respondent authorities, more particular the respondent Coal India Limited, on the ground that they have resorted to an illegal and arbitrary means to recover certain amounts without providing any details whatsoever and without providing any details. It is the category, be that as it may, one aspect is very clear, that the petitioners herein have not assailed as to whether the stowing charge excise duty as well as the royalty would form a part of the transaction value on which the central excise duty is liable to be paid. Under such circumstances, what transpires from the materials on record as well as the submissions so made by the learned counsels appearing on behalf of the parties is that the Coal India Limited is trying to recover certain amounts from the petitioners by issuance of this debit note along with the enclosures. It further appears that these enclosures to the debit notes issued to the petitioners are vague and lacks material particulars as regards in what transactions the petitioners are liable to make payment of the said amounts. This court at this stage further takes note of that as per the spot e-auction scheme of 2007, such dispute, Under such circumstances, what therefore transpires is that the Coal India Limited is trying to recover certain amounts from the petitioners. It would qualify to be a dispute. And the petitioners having rejected to make the payment, it would qualify to be a dispute coming within the ambit of clause 11.12 of the spot e-auction scheme 2007, which categorically mandates that if any dispute arises, the same is required to be resolved by way of arbitration as per the provisions of the Arbitration and Conciliation Act 1996. This court is further of the opinion that by issuance of a debit note and without giving particulars, the Coal India Limited cannot recover such amounts unless the same is duly provided as per the provisions of law, without following the due procedure of law. In view of that, as the spot e-auction scheme 2007 stipulates the procedure in case of such dispute, it is the opinion of this court that if the petitioner the Coal India Limited wants to recover such amounts, the said amounts can be recovered in terms with the said scheme read with the Arbitration and Conciliation Act 1996. Accordingly, the instant batch of writ petition stands disposed of with the following directions. Following observations and directions. First, the petitioners herein have not assailed as to whether the stowing excise duty as well as the royalty would form a part of the transaction value for the collection of for levying central excise duty. The Coal India Limited the Coal India Limited, the debit notes which have been issued and the enclosures therewith cannot be a means on behalf of the state Coal India to recover the amount, since proper detailing is being provided. Further to that, if the said amount is disputed, it would result in a dispute coming within the fold of clause 11.12 of the spot e-auction scheme 2007. And as such, the manner in which the recovery can be made has to be is in terms of the said clause, that is by way of arbitration. 3. The Coal India Limited is given the liberty to initiate proceedings if they wish to recover such amounts by following the due procedure, that is by way of arbitration, as in terms with clause 11.12 of the Spot e-auction scheme 2007. With above the instant petitions stands disposed.
However, the petitioner certain amount were lying which they have credited into their account, and therefore this honorable court had directed by interim order to keep those money in a separate interest bearing account which is lying with them. So they may release those accounts by
No, I say they cannot. I made it very clear.
I said,
It is absolutely crystal.
6 to 16, my lord.
Admission item 19.
Not to wait for the Supreme Court. Yeah. Instead of going to Delhi, I put her to Calcutta.
Ultimately,
Huh?
have to either to Delhi, okay.
Now she may go to Calcutta. Yes.
After one matter regarding refund of pre-deposit matter. One, the revision petitions were allowed matter. The other last day lordship well desired, which that if I could file an affidavit.
Yes.
one of the
Affidavit
bringing-
filed on behalf of the petitioner.
Yes, sir. We have filed an affidavit for bringing on record the challans, my lord, by which this pre-deposit was paid. Because on the last occasion, the confusion was there that whether the amount which we are claiming also included the tax component, my lord.
So these are all
All
payments
pre-deposit.
towards
Lordship.
pre-deposit.
Pre-deposit, my lord. Because the date of deposit, lordship, are all after the assessment orders. My lord. And the aggregate lordship comes to that figure, my lord, 6 crore 36 lakhs 47,400.
When was the order passed?
My lord,
When was the order passed?
my lord, the revisional order.
Huh?
Revisional order lordship will find in page 197, my lord, 26 to 2020, two revisional order,
No, I'm not on that. When was this order passed?
assessment order.
The assessment orders.
Those were passed on 22/3/2011, 15/7/2011, 25/7/2011, and 29/2011, in the year 2011.
Now, when did you, what resulted in you to deposit this amounts?
My lord, this
There
amount
must have been some orders.
orders by the Honorable High Court, my lord.
Where is that?
My lord, it is here, my lord. Lordship will find the Honorable High Court order, my lord, at page 90. My lord, 87, from 87 onward it starts, my lord, of the writ petition.
Did not comply with the order before and had not paid 20%.
If your lordship will this page 87, this is the order dated 18/12/2014. In some of the revisions, we could deposit some amount.
No.
Yes. Yes.
Order of the appeal authority and the fees paid out for non-deposit of the 25%. What is 20% of the principal amount?
Lordship, some relaxations were given and the subjective satisfaction of the
So
revenue.
you won 35 lakhs.
No, my lord, 6 crores, my lord, which was deposited in respect of all the revisions. Total aggregate comes to 6 crores.
This is only one order.
My lord, the subjective satisfaction of the revisional authority before admitting the revisions pursuant to Honorable High Court's order, including their own order, is in page 96, my lord.
Lordship, there were two orders of the High Court.
Two orders. For one assessment here, it was 25%, 2005-6, and when the subsequent assessment, it was lesser amount.
And rupees 35 lakhs each for assessment year so and so so and so. Order of the Honorable High Court duty. So you paid 35 lakhs each for 6, 7, 7, 7, 7, 8, 8, 9.
8-9.
So this comes around 1 crore 5 lakhs.
So my total amount, the total amount which we have deposited as pre-deposit is through the affidavit I have brought on record. It amounts to matter 6 crore 36 lakhs 47,442. And this amount has been admitted by them in their own notice. If your lordship peruses page 153 of the writ petition. When I demanded back the, my lord, the pre-deposit amount, they so-caused me. In that so-caused, they have admitted this, my lord.
And
153, if your lordship peruses, annexure P, my lord. The second paragraph. And whereas in spite of knowing above facts, you have applied for reform of security deposit for admission of appeal by letter dated so and so for rupees so and also claim interest of so and so, enclosing 4 applications so and so. So my lord, this is well known to them that this is the pre-deposit amount.
now, Mr. Chaudhary, you have challenged those orders before this court. Didn't it?
Yes, we had filed appeal before the appellate tribunal, but due to lack of quorum, it was, it has.
So you have exercised 226
Yes.
here. Now,
Lordship has issued notice. Some of the cases were listed yesterday before another court
Huh?
as well. Some of the cases that we have challenged, writ petition, Lordship, they were listed before another court yesterday, but due to paucity of time, they did not reach, Lordship. Initially, Lordship has issued notice.
we do one thing. You have it on Thursday. Along with that, we bring those. Get ready with those matters. It is.
Lordship 8.
You get ready with that matter. Have you received?
But actually, we have not received notice, madam. My
Lordship,
client has
we
not
have
received.
taken step. Have taken step, Lordship.
But my client, I have taken specific
You
instructions.
do one thing, you serve the copies to him. You will appear,
Okay, I'll leave.
you serve copies to him in the meantime, and you get the file of wakalatnamas in those cases. We'll take it up next Tuesday. Let him serve the copies.
12, my lord, some parts. Can it be on 13th, my lord?
Lordship, can it be after 18, Lordship? I also. Can it be after 18, any day?
19th,
Yes, my lord. 18th, it can be on 19th. 19th.
we have it on 19. In the meantime, you serve the copies. And we list this matter along with those writ petitions and get ready for final disposal. What are the numbers of those cases?
Lordship,
This court have duly heard the learned counsels appearing on behalf of the petitioner as well as the state respondents. Mr. D. Chaudhary, appearing on behalf of the Finance and Taxation Department of the Government of Assam, has submitted that the instant writ petition is connected with various other writ petitions so filed by the state of Assam, challenging the revisional orders passed by the Joint Commissioner, by the Joint Commissioner of Taxes, on the basis of which the petitioners herein are claiming the refunds. This court, upon hearing the matter at length, is of the opinion that for the interest of justice, the instant repetition be tagged along with the other repetitions being so and so, so and so, so and so, and be listed on 19th of November 2024 at the top of the list. Mr. G. Rahul submits that he has been verbally instructed to appear on behalf of the writ petitioner in those writ petitions, and he is also taking steps for filing the power in those. Accordingly, the counsel appearing on behalf of the petitioner, accordingly, Mr. B. Chaudhary is directed to serve extra copies of those writ petitions in WPC number so and so to Mr. G. Rahul by Thursday. You can file your affidavit. I can't write more.
Briefly, Lordship, two of the case numbers are 4463, 4465 of 20. 4463, 4465 of 2024. Lordship, two numbers yesterday, the two of them were listed. One has not been listed. The others are also in the.
Give the numbers.
Yes, Lordship.
Give the numbers of those.
Item 21.
What is this?
The last official lawsuit has suggested him why he does not approach the RCT. Why he doesn't approach the RCT instead of directly coming to the High Court. He is as railway claim tribunal. Because the question of fact that whether he's a passenger or not, this court is not going to indulge on. So that part in the evidence test, RCT is the proper form. So I also agree with that person.
It's another pen. Honorable High Court order also one of the earlier order units. In this case, the section 161 of the Railway Act is comes. Then learned tribunal has the no power. There is an earlier order of this honorable court, but honorable court has ample power to pass any order. So,
But whether you are a passenger or not, isn't it a question to
sir, all documents and inquiry also here, untoward accident report also here, police report also here. I am not a passenger. I am post a level crossing. Thereafter, I was victim run over by a railway train along with a scooter.
Huh?
Along with a scooter. He riding a scooter.
So you are the, who are you? You are the husband, wife,
I'm the next kin of the victim.
victim expired,
Victim expired already, have expired.
being run over by a train,
Train.
and you are claiming compensation here.
Not.
RCT is not the forum?
RCT generally, you say this is
How much should we pay? 1 lakh. We are going to exercise only a constitutional power, provided there is a negligence, apparent negligence.
Then there is a lordship already. It is a 8 lakhs. It is a 8 lakhs. You are saying railway accident and untoward accident compensation rules 1990. If person is dead, then it is 8 lakhs.
Account, This is by the tribunal only. Then why should we exercise? Unless you show that the railway claims tribunal cannot, then we have to exercise.
Section 124A laws. Compensation on account of untoward incident. 2 or 3 conditions has to be satisfied. It has to be course of working of a railway machine. Had he been a passenger in that train or in the state platform lordship, then some untoward incident happened, fire, robbery, then lordship.
The railways have to. How is this helpful?
Odisha High Court.
Huh?
Odisha High Court order. Odisha High Court order.
How is it helpful?
Radio authority is committed to deliberate negligence regarding. And there is another section also, 161 railway. There's the act, you're not it?
And railway claims tribunals. untoward accident would not come within the ambit of level crossing.
Under
You just crossed on what?
124
How?
Under 124 1.
124 A.
124?
124 1. 124 A. sorry.
124A, how will it come?
The first one, when in the course of working of a railway is there, was it?
Then,
When in the course of working of a railway means, was it?
when in course of a working,
Working
course
a
of working a railway,
But in this
a
case, it's not
railway.
working a railway.
an untoward accident occurs.
Yes.
The untoward has been defined.
That's it. That's also.
What passenger is there? He is not a passenger.
It's not a passenger. This fundamental not a passenger.
Therefore, how will he go? He can't go to. Huh?
It's a,
The writ is not maintainable. He has to go and file a civil suit.
in fact, 147, it is a punishable offense. Yes, section 147. Trespass and refusal to desist from trespass.
What is the jurisdiction? The position is where, what is the jurisdiction of the tribunal? Name tribunal shall exercise only from the responsibility.
Regarding passenger, section 124A, your lordship. Explanation 2, your lordship, page 47.
So therefore, if you are to go to the civil court, not the tribunal,
Lordship, kindly. Section 124A Railways Act, explanation 2, your lordship, last page 47. I read lordship. Explanation 2, a person who has purchased a valid ticket for traveling by train carrying passengers on any date or a valid platform ticket and becomes a victim of an untoward incident. I am the victim of an untoward
you
incident.
did not buy a ticket.
Also, the definition of untoward incident is at page number 46.
I'm looking to it. That is why I said, no, untoward incident has been defined. Now, you can't be a passenger. A person who has purchased a valid ticket for traveling by train, carrying passengers, or on any date, or a valid platform ticket, and becomes a victim of an untoward accident.
And
Did you buy a platform ticket by going on a scooter?
accident.
Untoward accidents has been defined, Mr. Counsel. Kindly see. Untoward C2, accidental falling of a passenger from the train carrying passengers. So you would not come within. You may go tomorrow with a platform ticket to see of somebody and then fall down from the train, then also you will be entitled. But recently I came across a judgment of the Supreme Court. Very recently it has been given. There are some. The case has gone from Guwahati. You aware? Huh? No, but there is this mention of something else as regards. Normally, it should not be something. The proof. There is some. Hmm?
How to prove that a person was a bona fide passenger and he was a victim of he said that
No, the burden is upon the railways.
initial burden is upon the victim.
And then no.
If they discharge the burden, then the owner is on the.
But that is what the Supreme Court said. So he has, but it is that he did not have a platform ticket or something. And then also it says that it is for the railways to show that. That is what has been stated there.
Discharge the initial burden by way of filing an affidavit or stating that
I
someone
was
has
there.
seen,
Yes.
has seen the person purchasing a
Yes.
ticket and boarding the train. So the owners got shifted over.
Yes. I remember. There's some lawyer from Assam who did it. Huh?
This judgment also follows the landmark decision for.
Leena Devi.
Leena Devi.
Yes. But you have to go to the civil court.
This is a runover case. In case of runover case, your lordship, it comes to the inquiry of the railway also. Kindly see your lordship. Rule 4 of the Railways Passenger Manner and Investigation and Untoward Incident, Rules 2020.
Rule?
Rule, Lordship. Passengers manner of investigation of untoward incident, bracket close.
Very good.
Rules 2020.
No, railway accidents and untoward compensation rules. Then
20. Along with this claim tribunal, railway claim tribunals.
railway accident and untoward incidents compensation. It is there.
Passengers, bracket manner of investigation of untoward incidents, bracket close. Rules
not here.
2020. Okay.
But if I have to pass an order, I'll have to also say one thing, that you cannot go to the RCT. Therefore, you have to file a suit. Otherwise, I will be again have a problem.
Lordship, it is this Railways Act 1989. This book, your lordship. Kindly see page 102A. Yes, 102A. This is form number 1, your lordship. Report of untoward incident. Nature of the untoward incident. Accident, fall, bomb blast, rioting, shootout, arson, dockery and robbery, violent attack, terrorist act attack, run over, trespass.
can be run over. Platform ticket. If you purchase a platform ticket and jump in front of the what you call the track, it may be run over. Accident falling under, because untoward incident is indulging by any person or in or any train carrying passenger or is waiting hall, cloak room or reservation, or yeah, the accidental falling of any passenger from a train carrying passenger. So anybody may be run over. There are two tracks, two trains are going, one train, one of the fellow jumps from one train to the other. You see it in Hindi movies.
Actually, what happened also, at this railway traveling, crossing level, your lordship, it is not also unmanned, it is manned. Some negligence on the railway authorities also, because kindly see.
Very well, why are you not going to the civil court and getting a huge compensation of 1 crore? Why you are letting off with 8 lakhs? But you have to prove that, whether it is meant or not, whether it was, there are many cases. I still remember there was a very important case. Reading it, there is a particular rule by which when you are having a man crossing, which side of the, nowadays you have this, what do you call, with one thing, they just lift both the rails, the gates. But earlier there was a rule out there to the effect that you are to open only first the area which is free. Then you open the second. You don't open the first one, and because there might be again a collision. What may happen is these people may come over. If it is the crowded area, if you open the gate first, this may come in and you don't close it, don't open the empty one, then they may get stuck. Something may happen. So it is also a rule at that point of time that you have to open the first is the area where road, which is clear the road, which is not so having so much of traffic. Second, you are to play with the traffic. These are many things, but these are all have to be done in the suit. Whether the manning was properly done, whether he opened it, whether he kept it open, whether the guard went to sleep, he didn't hear the sound. Many aspects of there.
So in fact, the ability to have stated losses, this particular railway crossing is not unmanned losses. In fact, in the upper Assam, at Tinsukia, Dibrugarh, there is no, they have cleared all the unmanned. So it is an unauthorized level crossing. And there is a signboard that whoever that crosses there, it is punishable under law. 6 months and some fine. So he has done it by crossing it with a scooter.
But at the time, there is a no signboard.
No, I have to annex the form.
Annex, but it is subsequent.
That cannot be. Lordship, they see the condition of the signboard.
So it is, how will I see? First of all, that person who had seen is somewhere else. The person who has filed an affidavit or filed a petition, he was not there. Whether that signboard was there or not. What do you say? Whether it is there. These are all questions of proof.
It's also some photograph also, along with GPS camera, giving date also.
For what? Being a counsel from the civil side, I love to hear these civil matters. But the problem is my jurisdiction is different.
And liberty given because there is a convention of delay is coming. Convention delay also come.
So each period, when did the incident happen?
26/11/2022.
Time is there, 3 years. 3 years. Till July 2024. Well, we pass the order tomorrow at 2. Business matter tomorrow at 2 o'clock. Pass the order.
So, I'm, my relative also only the today's date. No, my one relative also died also today. Tomorrow
You are not required. I'm passing that order tomorrow. You see, I don't want you to wait after 4:45. That's the court working hours. If I start dictating it, it will go to 5:15. The other councils may not like. I'll pass the order tomorrow at 2. You can ask any person to be there, but the thing is, I will hold it that the RCT does not have the jurisdiction. I will hold it that this court would not like taking into account various disputed questions of facts would be required, and as such giving you the liberty to go and file a court of error. Because I will say RCT does not have, because tomorrow you never know, the railway will again jump in and say that RCT, go to RCT, which he said the first thing in the morning.
I accommodate that I am also some desire to wait in that court. So can you 14
Okay, day after tomorrow at 2.
What's 14 lots?
What? No 14 weeks. I'll forget. Day after, okay?
I'm not available. Tomorrow also I'm not available.
Ask his friend to appear.
Okay, lots.
You have your junior
Yes, you say someone I will tell you.
to be there tomorrow or day after.
32.
Yes, what is this?
It was related to land acquisition, Your Lordship. The petitioners are the land acquisition matter, Your Lordship, by the National Highway. In case of the petitioners, the possessor of the title of the land, but the money has been released in favor of the respondent number 6, which is stranger. Lordship, I'll put the respondent number 6 here.
Oh, this one.
Yes.
Where he got the money only for those trees or something, not for the land or something, isn't it?
The respondent number 6 here. Actually, I will file affidavit within short week. Within short days, within 7 days, Lordship. Actually, I didn't get any document, only one document I have received. Actually,
Okay, what is your name?
MS Alam. MS Alam.
And so appearing on behalf of the respondent number 6 submits that he would like. No, these are matters not to be adjudicated by this court. This matter should go somewhere else. Mr. Counsel, I'll fix it on 14th only. Yes, railway. I'll fix it on 14th only. 14th you are there. No, not on 14th. Come before that. We'll have it on Monday, next Monday. Make yourself available on next Monday. Okay? Okay, counsel appearing on behalf of the respondent number 6 submits that he is appearing today and he would like some time to file an affidavit in opposition. List this taking into account that the matter taking into account the above, this court fixes this matter on 20/11/2024. In the meantime, the affidavit be filed by the respondent number 6 by 14th of November 2024. 14th of November, you file your affidavit. Petitioner would be at liberty to file the reply.
Fixed it not on 21, in it at 19 or in it at not
21. Yes. Any urgency, any extension of interim order, Mr. Saibola?
Item 74 is a blacklisting matter, my lord. May I play blacklisting matter? of the contractor. So may I pray, my lord, the matter may fix the next week, my lord, 12 or 14, any day, my lord.
12?
Much.
Blacklisting, na? 12, top of the list. Item number 24, no? 74. 24, on 12.
My item number
24.
73. 73. I have come from Shillong, so I think date may be given.
73. When do you want? When do you want it?
Please take in this month. Secondary report, 30.
Yeah, you enjoy the cherry blossom festival there.
No, I am
Yeah,
only.
what is there to be here? What is the matter about?
This is regarding barter trade activities. There was I am
Huh?
an exporter importer
You are a? Huh.
of barter trade. Barter trade agreement 21 1994. That barter trade provision was it was formulated by RBI, and suddenly it was rescinded. Condition was that this export and import has to be balanced within a period of 6 months. That chance, no notice was given. Suddenly it was rescinded. So RBI finally, understanding the difficulties, they have approved that PNB, this designated bank, may permit the import remittance. But they are not obeying the RBI letter.
Who?
This PNB, Punjab National Bank. And I refer your last order 30/10/24, my lord.
Yeah, who did?
24.
Shiron Ranjit Singh.
Yes, Shirom Ranjit Singh.
This is an IABing file.
I also identify because I need some interim protection. Because no, in the meantime, the dependency of this litigation, no coercive action will be taken by the enforcement authority.
Okay, when do you want it? Now we'll fix it for orders, this matter. When do you want it?
As per your comment, my lord.
No,
After
no,
14th, after 14th,
we'll fix it on a motion day. When do you want it?
after 14th, 11. After 14th.
14?
Yeah, 14th, I am having.
Okay. This matter again on 20/11/2024 in
Yes.
the orders follow.
Much of this.